May I have a lordship slip, my lord? We were
Yes.
very urgent motion. My lord, yesterday, my lord, the invocation for bank guarantee letter has been
Mr.
issued.
Dotto, I take up mentionings only on Monday and Thursday. If I make an exception for you, that will make it send a wrong signal.
My lord, could I, my lord, seek leave of your lordship's court officer to file it, my lord, in course of the day with short notice? It's
Very well.
being
Please grant.
prepared.
Yes.
Sometimes, my lord, around 1 o'clock,
Yes.
if I may.
Yes. Do that. Yeah, leave to you.
One
Short.
dismissal for non-prosecution, item 44.
Item 44.
Dismissal for non.
To be mentioned. Two orders to be mentioned.
To mention for
Come back
correction.
tomorrow. No other mention. Yes.
For correction.
Call for a list.
To be mentioned item number 1 for release.
কি বলছিলে?
I appear on behalf of the petitioners, my lord. This matter was initially released by Justice Mongshumi Bhattacharya, my lord.
So that's why I should also release it.
My lord, this matter relates to Group 4, my lord,
Oh,
service. My lord can take up this matter otherwise.
I don't have determination. Group 4 you are saying?
Group 4 service, my lord.
The
It's a
matter.
pension
Oh, yes.
matter, my
Right.
lord.
The matter pertains to Group 4 as per submission of learned counsel for the petitioner. First up, let the matter go out of the list accordingly due to lack of determination, with liberty to the parties to mention for enlistment before the appropriate bench having determination.
My lord, one short innocuous mistake on my part, my lord. It was Group 6.
4 to 6 way. Thank you.
Grateful.
We mention item number 2 for non-prosecution.
May it please your lordship,
Prosecutor?
I'm appearing on behalf of the petitioner in this matter.
Right.
Your lordship, we had mentioned this matter on Monday. We have instructions to withdraw.
Without liberty.
Without
Lordship, I am appearing on behalf of the state lordship.
Like.
Lordship, kindly every in opposition may be kept to the record, Lordship.
Affidavit in opposition filed by the state be kept on record. Full stop. However, in view of the submission of learned counsel for the petitioner that the petitioner wants to withdraw the writ petition, there is no effective purpose in extending the time for filing reply. Full stop. Accordingly, WPA 22280 of 2023 is dismissed as withdrawn without any order to cost. Thank you.
Grateful, your lordship.
Upgraded matter item 3.
Item 3.
Yes, Mr. Chairman. 2019, don't have determination. 2019, I have determination since 2021. That's in my list. Due to lack of determination, let the matter go out of the list. Full stop. Liberty to the parties to mention for inclusion before the appropriate bench having determination to take up matters before the year 2021.
Item 4.
Yes.
May I please, your lordship?
Yes, you are appearing in person.
Yes, I'm
Right,
appearing
right,
in
right.
person, Dr. Anirban Chatterjee.
Yes, yes.
This matter relates to one of the medical negligence cases dating back to 2015.
Right.
And simultaneously, the
You are for the medical council?
No, already matter disposed of.
No, that I'll hear. You are for the medical council?
Yes.
Right. Well, let me hear, Doctor. Yes.
This was again, actually, the complainants also took it to the NCDRC, and NCDRC sent it for expert opinion to the AIMS. And from 2019 to 2023, 2019, the Penal and Ethics Committee called me from the West Bengal Medical Council. I had submitted all details with everything there, and the full question answer and everything which was there, it is with me. If you
What is the grievance now?
Yes, if you want.
No, what is your grievance now, Dr. Chatterjee?
Yes. The thing is, in 2021,
yes,
suddenly I got a notice from the West Bengal Medical Council that yes, it's annexure. It's annexure P7 page. Sorry. It's annexure P8 page 101.
Disposal হয়ে গেছে তো আপনার পরে নেসেসারি কেন
আমার পরে তো হয়নি আবার চিঠি পাঠিয়েছে তো
না না
Yes. Of a different matter.
maybe.
Yes.
So this was done without hearing you? With after hearing?
After the Penal and Ethics Committee meeting, the details of which I have here with me. If you want, I can submit to your lordship. If your lordship wants, I can.
So what is your ground of challenge, Dr. Chatterjee?
Yes, the ground of challenges, I have written to them everything that in detail, that it is already in the NCDRC and the AIMS expert committee is already on it. So the same thing can't be determined on the two forums. Next is two parallel proceedings can't go on at the same time at two forums. Second is the letter actually which was dated, as you can see, it is asking me to submit all my original documents even before the hearing, failing which it will proceed ex parte. Whereas in the Bengal Medical Act, nowhere is it mentioned that all my documents have to be submitted in original before the hearing to decide on whether my registration will get cancelled or not.
Second ground is not a very strong ground, Dr. Chatterjee, because they may very well ask for, because for a proper hearing, the documents are necessary, obviously.
No, all the document copies were already submitted to them, but they're asking for the originals even before the hearing.
But that was not a ground of reject, passing the order against you, that you have not submitted or something like that.
No,
But two parallel proceedings satisfy me on this. What is the other proceeding about?
other proceeding is on the same case, my lordship, at the NCDRC for medical negligence, which the NCDRC sent it to the AIMS expert committee, and they have actually given the report very recently, which I didn't get the certified copy at the last date of mentioning, which is now with me, and they have cleared me completely of all negligence. And even I went to the Supreme Court with it, and the Supreme Court also asked the AIMS to give the report promptly, and they have given a detailed reply, which your lordship, if you want, I can show it to you, and if you want, I can submit it through another interlocutory application, whatever.
Supplementary affidavit should be. Let me hear the contours of the defense. Yes, please take your seat, Dr. Chatterjee. Yes, what is your? There are two primary submissions. One, original you could not seek, could not insist upon before hearing, and second is more important, parallel proceedings. He has been absolved from one. So, what is your answer to that?
So far, I may be misguided. My lord. Another subsequent writ petition was there,
By a different person?
and it was a 23 writ petition that was disposed of.
Dr. Chatterjee's application?
Yes, but it might be a separate.
Different.
separate-
What is the answer to these two questions?
My question is now after the promulgation of the new act, national commissions, only the state medical council is authorized to take action against the registered medical practice. Not even the National Medical Council at the first instance cannot do anything. There is a provision of appeal. Under the Bengal Medical Act, there is a provision of before the state government. Under the National Commission of Section 30, there is a provision of second two appeals. First appeal, again, if we agreed by the yes, then there is a provision of the second appeal. So only the state council has the primary authority and to take steps against the registered member. So far, there is a codified statutory guidelines, there the rules we have.
Satisfy me on the statute, please place the act.
Lord, I have sent it. Lord. Bengal Medical to নিয়ে আসবে national committee.
May I?
No, let him complete. Very well, that is your main defense. Yes, let me complete his hearing. Yes, please take it. Dr. Chatterjee, there are two things I'd like to ask you. One is, why isn't this premature? Because you have been asked to appear before them only. So go and appear and take all your points.
I'm telling you, everything's.
You don't have the point that they don't have jurisdiction. They otherwise have jurisdiction. Because
There are a few more points actually, my lordship, if you go back to it. 2018, it was actually taken as a case of medical negligence, and the entire hearing of the Penal and Ethics Committee was done based on that. 5 years later, when they sent me the letter, if you just have a note of it, the stance have completely been changed. They are now saying the diagnosis was wrong, the treatment was wrong, and everything, to which all evidences have been submitted, to the extent that the Gangaram Memorial Hospital, where the girl was ultimately treated, specimen which was removed at the time of surgery proved that it was a vascular malformation, and those documents are also with the West Bengal Medical Council submitted a long time back.
what was your alleged role in this?
I was the treating physician who underwent the embolization, which is a non-target embolization, is a known complication, and which actually, if you kindly go through the AIMS report.
Then you have to give a copy to them also.
Yes, I will give them a copy, definitely, sir. If your lordship, please. Yes, just 2 seconds. I mean, yes.
You don't want a copy? Why? Touching the copy won't affect you in any way.
No, he is
That is
asking for a
going in
copy.
your lordship, so I'm asking for the copy.
I will give you the.
No, give a copy, give a copy.
Yeah, I will certainly give him his copy. I have it in my bag outside, your lordship. I haven't brought it in here with me. And not only that, your lordship, even the NCDRC, by 30. Yes.
Dr. Chatterjee, there is a subtle distinction between the jurisdictions of NCDRC and medical council. NCDRC is more on a consumer dispute. So your medical negligence, that will be paid. Some damages may be awarded against you and some civil disputes basically. But this is a penal action. Under this, penal action can be taken against you.
I fully
These
appreciate.
operate in different fields.
I fully appreciate your lordship.
Participate there, take all your
No,
points.
Not only that, your lordship, they are changing the stance completely. They are asking me to submit all my documents before the hearing, which actually goes for a post-decisional hearing, basically. And it is a violation of natural justice. And not only that, it reflects institutional bias, the change of stance.
Which
Despite
portion of this notice? Which portion of this
the
notice?
very first, if you just go through the
Yes.
notice, the last portion, the last para, which clearly goes, and the points which were highlighted, that all points have been changed from the original letter, where the complainant never actually challenged the diagnosis or everything, and the West Bengal Medical Council has in hand the proof from Gangaram Memorial Hospital that it was a vascular malformation, and still they are trying to change the stance that you are wrong on your diagnosis and you are wrong and everything. And ultimately, even I have the Supreme Court order with myself.
But you are entitled to produce all these documents before the council. Go and produce the
I
documents.
have produced everything. Now, if I
No,
produce,
this is only a show cause you are challenging. You have been directed. You have been given a date of hearing. So go there, participate, produce all these things.
I fully
Even
appreciate-
after that, if they do it, then you can always come
Yes,
up with challenge.
yeah, I agree fully, my lord, your lordship. But if they cancel the amount of disrepute, I'm giving a small example. Recently, a gynecologist, even before the hearing was done, it was published in the newspaper by the registrar himself. So the amount of disrepute and the law damage to my practice and my career, will the medical council ever be able to give it back to me through the years of my practice? And you can see the AIMS report, your lordship, the last line of the AIMS report, where they have said, rather the best possible medical care has been provided.
Do this, Dr. Chatterjee, please put this on oath by way of a supplementary affidavit.
Yes, sir.
And whatever other documents, your Supreme Court judgment and all these things, whatever documents you are now saying you're relying on, please produce those by way of a supplementary affidavit, give a copy to them, come back within a week.
Absolutely.
Can you do it within 2-3 days this week?
Yes.
So do that, give a copy to them. No.
Which?
You will have to annex these documents. You'll have to file a supplementary affidavit. Get it affirmed during the course of this week. Today, this week, 2 days are left only. So I'll give you a week for doing that.
Next Tuesday?
Next Tuesday, I can put it next Tuesday, but you have to give a copy to them
Absolutely.
by this week if possible.
Absolutely, sir.
I'll do that.
In the meantime, your lordship, 5th is the day when they have called me for the hearing. They might actually, they have said that they might decide ex parte.
No, I'll stay the operation for a limited period for 2 weeks.
But this is a kindly appreciate. They have annexed page 103. This is the rules, conducting rules of the by the medical.
And another thing I will.
I'm not saying you don't have jurisdiction. I cannot.
Another thing which I will.
I cannot say that, but I want to go through these documents. I want to go through these documents, and you also have to go through these documents and look into it. If after this it's necessary, then we'll.
Another small point I will highlight. The Bengal Medical Act, para 19, if you see, which is attached with the letter, your lordship's pleasure if you watch it.
Yes.
It says that I am entitled to get all the copies of the documents submitted by the complainants, depending on which the medical council is charging me with these new clauses.
They have not given you any copy.
I have applied from that time a given letter, which is actually attached with the filing document till date. They haven't replied anything and they haven't said anything at all. And even on a sub judice case, they are repeatedly doing this.
Very.
And even the last case, which I will small intervene for you, the last case.
Dr. Chatterjee, let us come back on the next date and we'll hear all of you.
Okay.
But use this first.
Kindly ask the petitioner to annex also that application which is made after before the council. After
annex everything, whatever is relevant in your.
Yes. After issuing charge sheet, they have asked for documents. They have not given.
It's already there. I will give it to you.
Should I direct affidavits to be affidavits to be filed by you also?
Then
Because I
they-
don't want to do that at
No,
the
they-
inception. This can be decided upon looking into his documents.
Then they have to be delayed.
Maybe this will culminate, this writ petition can culminate by me directing you to furnish all the copy of the complaint and all the other documents to him, and then give him a right of hearing. This may be one of the
There
options.
is provision, if he asks, then we will supply. If he don't ask, that's why I'm asking, let him produce the application after the
He's
issue.
asking now, you can give him a copy.
Otherwise, he will participate
The
before the council.
petitioner appearing in person with the leave of the court challenges a show cause notice issued by the West Bengal Medical Council on August 31, 2021 to the petitioner. First up, it is contended that the show cause notice reflects a preconceived perception against the petitioner. First up, secondly, the petitioner has been directed to produce his original certificate before the hearing takes place, which vitiates the veracity of the hearing. So thirdly, the petitioner submits that the same complaint was made before the before the Consumer Disputes Forum and went up to the National Forum.
No,
Up-
it was directly filed in NCDRC.
Oh, very well.
22 crores.
The self-same
compensation.
complaint was filed before the National Consumer Disputes Redressal Forum,
Copy জানেন আপনি?
which held in favor of the petitioner. Push up next para. The petitioner seeks to produce relevant documents in that regard and contends that there cannot be double punishment or parallel proceedings in respect of the self-same cause of action. Push up next para. Learned counsel appearing for the respondents contends that under the law, the West Bengal Medical Council is the body which exclusively has power to deal with the issue involved. Push up that apart, it is argued that the petitioner had not asked for copies of documents, including the complaint, which he is now insisting upon. Push up next para. Be that as it may, since the petitioner seeks to rely on further documents which are not a part of the writ petition, the petitioner shall file a supplementary affidavit annexing all relevant documents on the next returnable date. An advance copy of the same shall be handed over to the learned advocate for the respondent counsel before the next returnable date. The matter shall next be listed on April 9, 2024 under the same heading. The respondents shall be restrained from taking any coercive action on the impugned notice dated August 31, 2021 till April 19, 2024 or until further order, whichever is earlier.
Your Lordship, just a small mention. Page 107, 108, the proof of delivery of the letter asking for those is attached in the document
The
itself.
letter which they say you have not given.
Yes, which they are saying they are not given. The proof of delivery is there and the letter is attached.
We'll consider everything.
Affidavit of service is also.
At a line. Yes.
Thank you. I'm grateful.
Item 5.
Yes, my lord. I appear on behalf of the respondent.
I appear on behalf of the Panchayat. Before starting my argument by my learned friend, I filed a writ petition related to the same issue. And your lordship can it be tagged along with that petition so that it can be heard analogously?
Subject to lordship, I have also filed same, my lord, challenging the.
Give the numbers on slips of papers.
It appear tomorrow.
On slips of papers, please ask your juniors to hand over the numbers, both of you, Mr. Dotto as well as Mr. Banerjee.
My lord, state respondent has to file report.
May I file my report?
Yes, yes.
Advance copy has been served.
No copy served.
Advance copy has been served.
Very good. The learned counsel for the state files the report as per previous direction. It is contended by learned counsel appearing for the respondent number 12 and the respondent number 13 that they have filed independent writ petitions regarding the self-same cause of action. No, self-same. Regarding the same issue. Accordingly, let the said writ petitions bearing numbers such and such be listed along with the present matter under the same heading on April 8, 2024. Please exchange copies in the meantime.
Yes, my lord. We went to sub, my lord. He has indicated.
At a line at the parties shall exchange the copies of their respective writ petitions
I have,
in the meantime.
my lord.
But the matter will stand on the same heading.
Same it, yes.
8th. I'm good.
8th, next Monday.
Item 6.
None appears for the petitioner. You're
Yeah.
appearing, Mr. Banerjee? Yes.
There was a direction, my lord, of your lordship, my lord, permitting, my lord, the respondent to use their affidavit in opposition.
My lord, the affidavit
13th
in
of March.
opposition is ready but could not be affirmed. I am seeking for a.
Affirm it today, file it tomorrow.
My
Why
lord,
could not it be affirmed? Use the mic, please.
my
There
lord,
is a microphone in front.
my lord, the dealing officer of the respondent company is not available due to that reason, my lord. It could
Not
be affirmed.
available? Why?
My lord, he is on leave due to sickness.
After getting the order?
My lord, it was ready.
He
He's on.
became sick after or before?
My lord, he is on leave for the last week.
Then after?
That is after the order.
Somebody else has to affirm it then.
My lord,
Your work is stopped. The coalfields has stopped working for him.
my lord, kindly give me 1 week's time. So
I'll
that
give you
I
1 day's time. Do it by tomorrow.
oblige, my lord.
Learned counsel for the respondent seeks an adjournment and an extension of time to file affidavit in opposition. Full stop, next para. It appears from the records that sufficient time was given in the first place for filing of affidavits in opposition. Full stop, however, comma, keeping in view the predicament of the respondent, the matter is, and the time for filing affidavit in opposition is extended till. Mr. Banerjee, I'll give him 1 week. He won't be able to do it tomorrow. Your learned friend will be in difficulty.
Yes.
Is extended till April 11, 2024. Reply finish shall be filed by April 18, 2024. The matter shall be listed under the same heading on April 22.
Oblige.
Item 7.
Yes.
For the state.
My lord.
Yes. You dare to ask Mr. Ganguly whether he's appearing for the state? He is the state in this court.
State respondent.
Yes, what is the matter?
Matter is, my lord, regarding a mela.
Take a seat,
that
Mr.
is the
Ganguly, and
holy
your lord.
fair, namely Baruni Punno Snanjatra Mela, that was held after 12 or 13 days of Dol Purnima. And this mela was very primitive and very ancient time. And year by year, the mela has been performed by the petitioners committee.
Right.
That is the Baruni Mela committee. But in the year 2022, namely Orchit Nondi, made objection that the Mela, some part of
You're
the
for Orchit Nandi?
Madam, what happened? I have not made a party. I have something has been recorded against me, against Orchid Nondi. Now,
You're Orchit Nandi. You're
yes, my lord.
now, madam, I don't know, but suddenly matter has come. Kindly takes up tomorrow, madam.
My lord, I have strongly objected because they file one can application
I filed
that
application for
at
addition
the
of party,
time of
and
because
he mentioned the matter without serving any notice.
my
Good.
lord, I served notice because the
So you are not at party, that's why he did not serve you.
I
lord,
filed addition.
till now they are not party.
I filed application for addition of party. Copy has been served upon him.
Application for addition of party. Okay, রাখো তো।
Upcoming Saturday Mela will be
Addition
started.
of party application টা কোথায় আছে লিস্টে?
But madam, no copy for upgradation, no notice was served.
Come back tomorrow.
My lord,
An adjournment is sought by the proposed added respondent. Let the matter stand adjourned till tomorrow.
my lord, kindly fix the top, my lord, because Saturday, because upcoming Saturday Mela will be started.
Could have given a notice to him. We could have heard it today itself.
My lord, that
Why do this?
my lord,
Somebody has filed an application for addition of party
because
without
my
giving
lord,
a notice.
the state is the main respondent.
Anyway, let us call on
and
the next
answering
matter.
because, my
Item
lord,
8.
They will also.
Fine.
Yes. 8 who is appearing?
No one can appear.
None appears for the petition at the time of call, although the state is represented through counsel. Full stop. Let the matter be listed under the regular heading on Monday, April 8th.
Item 9.
So what you are in 9?
Yes, my
Yes.
lord. Sujit Kumar Ghosh is appearing for the
Is
night.
appearing?
Sujit Kumar Ghosh. My lord, he is went to his native village for his father-in-law, my lord. My lord, 9 and 11, my lord, I'm praying.
But Mr. Bhatto, then it goes under the regular heading if the petitioner prays for time.
But I am for the distribution company.
Yes. What is the matter about?
Billing dispute.
What is the matter?
My billing dispute, my there is a huge accumulation. They prayed for waiver, but waiver we cannot allow. Ultimately, Ombudsman rejected the same.
Acha, let them move it. An adjournment is sought on the ground of absence of learned counsel for the petitioner. Let the matter be listed under the regular heading on, I'll keep it on Monday then, April 8, 2024.
9 and 11, my lord, same.
Let it be called on. Acha, 9 comma the 11 dekhi daw to. 11 also you are appearing?
No. No.
Comma the 11 there.
11.
মুখে কল করো 11
11
same order 10
I'm grateful, my lord.
11 you are appearing?
For the distribution company, my lord.
Yes, give your name. It will appear on Monday under the regular heading now.
My lord, all annexes are not served. I find that there are 6 annexes only. 3
Catch hold of
annexes
Mr.
are served.
Bhatto outside
All
courtroom and do whatever you have to.
petitioner.
item 10
Yes.
ঠিক আছে, আমি একটু দেখে নিচ্ছি।
10. Yes, Mr. Bhattacharya.
My item number 10, I am for CSC.
Right.
My in pursuance to your lordship's direction, an inspection has been carried out.
Yes.
And on that basis, this is the report. And the good thing is that the connection can be given through loop meter from the existing service. My one thing, it is my duty to bring to your lordship kind notice. There is one mistake inadvertently. But in the report, it has been written as a 1st April. But the inspection has been carried out on 2nd April. That I have already given notice to them. I just admitted position.
What is the position after?
My inspection is that if your lordship kindly see the report where it is very much clear that the address which has been given in the same premises and there is an existing service. From that existing service, a loop meter can be given, subject to compliance of all formalities. And if there is any resistance,
Mr. Bhattacharya's client has prayed for asked for a meter
electricity.
connection.
Yes,
Yeah.
your lordship.
Lordship, I'm for
You are for the private. Yes, you have the main say.
Yes, my lord. I have served with a copy of this report, my lord. To this effect, my lord, I want to take exception of this report.
No, what is your exception? Tell me.
Exception is,
Did
my
not
lord, some
delay for time.
documents have been handed over to CSC, which we don't have any copy. So we want to go through these documents.
What is your objection to his getting a meter? I don't
No,
understand.
they have served some documents.
No, documents forget. I'm not relying on any document.
Yes, ma'am.
What is the objection you have taken? Why are you objecting to their connection?
Objection is, my lord, we are not accepting them as the occupier of this premises. And they have served, they have submitted some documents regarding the occupancy.
This
of
is not
the
an
premises.
adjudication of that. It is the satisfaction of the CSC Limited which has to be considered. And I'll make it clear, I'll make it very clear that this will not create any equity in their favor or shall not prejudice your rights before any court of law.
To be candid, my lord, I have been instructed to take exception of this report by my senior, my lord.
I'll record that. Learned Counsel for the CSC Limited files a report, full stop. Learned Counsel appearing for the private respondent submits that the private respondent seeks to use an exception to the said report, full stop. On query of court, comma, Learned Counsel for the private respondent clarifies that the documents which were purportedly produced by the petitioner and referred to in the report were not handed over to the private respondent to enable the private respondent to raise objection. Now your senior will not at least say that you have pushed up. Next para. However, comma, this is not an adjudication of the private dispute between the petitioner and the private respondent. Full stop. What is to be prima facie ascertained by the distribution licensee is whether the petitioner has produced any prima facie proof of their occupation, his occupation. Full stop. Next para. Thus, comma, it is entirely between the petitioner and the distribution licensee to for the satisfaction of the the licensee as to such position. Full stop. In any event, comma, such satisfaction of the CSC Limited, which is the licensee here, comma, does not tantamount to creating any right in favor of the petitioner, which the petitioner does not otherwise have in law. Full stop. It will always be open to the private respondent to dispute all questions, comma, including those of right, title, and position of the petitioner in any appropriate forum, comma, if disputed. Full stop. Be that as it may, comma, it transpires that the CSC Limited itself is of the opinion that in view of the petitioner having furnished copies of a rent control challan and a certificate of enlistment, comma, the prima facie possession of the petitioner has been established, which is sufficient to attract the provision of Section 43 of the Electricity Act 2003, under which an occupier is entitled to electricity connection. Full stop. Next para. Accordingly, there is no further need to delay the matter by directing exception to be filed by the private respondent in view of the above reasons. Full stop. Moreover, comma, it has to be kept in mind that the petitioner is going without electricity, for which the necessity, comma, particularly in view of the impending onset of summer, comma, is extreme. Full stop. Accordingly, WPA 23190 of 2023 is disposed of by directing the CSC Limited to give a loop metered connection to the petitioner from the existing meter board position at the premises, subject to compliance of all formalities by the petitioner in that regard. Full stop. Such connection shall be given within a fortnight from the compliance of formalities by the petitioner or from this date, comma, whichever is later. Full stop. Next para. In the event any obstruction is offered by the private respondent or his men and agents, comma, it will be open to the CSC Limited to approach the local police station, who upon such approach, comma, shall act on a server copy of this order and grant such assistance at the cost of the petitioner, comma, if necessary, removing any padlock or other hindrance in the process. Full stop. Next para. It is, however, reiterated that nothing in this order shall create any right, title, or legal possession in favor of the petitioner if the petitioner is otherwise not entitled to the same in law. Full stop. No rest to cause.
That there is an inadvertence relating to the date of inspection where it has been determined.
আচ্ছা, very well. প্রথম লাইনে একটা অ্যাড করো না। Learned counsel for the CSC Limited, in his usual fairness, points out that an error has crept in the report filed to be filed today, inasmuch as the date of inspection has been erroneously mentioned as April 1 instead of April 2, 2024.
I have already circulated the report.
Yes.
What is your name, please?
Abir Das.
Abir Das.
Abir Das.
একটা জায়গা না যেখানে বললাম না, learned counsel for the private respondent, Mr. Abir Das, learned counsel for the private respondent. Your senior is in court.
No.
Don't give his name. Abir Das বলে তারপর not. Next. Yes. 12 who is appearing for the petitioner?
And for the statement.
My lord, I am appearing for the respondent bank, your lordship. Lordship, yesterday they have sought for an
Yes.
adjournment owing to that.
Yesterday an adjournment was sought for the petitioner. Full stop. Today, when the matter is called on for hearing, none appears. কেটে দাও, ওটা দিও না। Yes, Mr. Rai.
The opposition
Your
report.
car is giving you trouble today also
No. That was in that,
on that date. What happened to your car? I mean,
my lord,
nothing serious.
no, but car was badly damaged.
Badly damaged
And that's why, my lord,
in an accident. You are.
I have not any
Thank God.
injury, but car was badly damaged.
Yes. Yes. What is the matter, sir?
This is when the affidavit in reply.
What is the matter?
This is, my lord, petitioner filed this application.
Pension account 32,000.
Yes, deducting the pension from the account, which is savings bank account, but that pension was tagged with that account because there is, my lord, in the opposition, they have taken a stand. This account is not a pension account; it is the savings bank account. But so far, every pension account is the savings bank account.
No, not that. They have taken another point.
And
it has been contended by Ms. Roy Chaudhary on the last occasion that the deducted amount was not specifically from the quantum of pension. It also has other inflows from other sources. If that be so, we cannot label it as a.
That I will, my lord, show from
Mr. Rai, tell me what is the pension amount which enters there every month?
34,000 something.
34,334.
Mr. Rai, then you cannot have anything to say if they deduct amount leaving that 34,334 intact every month.
And after filing the writ application, my lord, subsequently, entire amount was deducted. Your lordship kindly peruse that the statement they have annexed at page 12 of their opposition. At page 12, only 4th April 2023, your lordship will find 33,347 pension March 2023. Thereafter, some account was transferred from another source, that is, my lord, 84,561, 55,256. I have explained my reply what from I got that amount.
Need not.
Then,
Yes.
my lord, that is the area of pension, that is 957. Then again 34,304
Pension, yes.
pension. And your lordship find that only pension and interest of that has been debited, credited in that account. Nothing
Only two amounts, this Mannapuram thing, only that is the extra.
extra.
Yes.
Otherwise, no. And
Right.
I have, my lord, withdrawing from that account. And thereafter, my lord, this is the entire amount which has been received. Now, my lord, kindly see that my affidavit petition, when I have, my lord, that the deduction at page 11 on 31st May 2023, 32,000 transferred to such and such account. Prior to that, I have not any deduction from that account or any other accounts from by the bank. Then I went to the
No,
bank.
this is the 31st May is the first deduction.
First deduction. And I went to the bank. They said, you have my husband has taken a house building loan. That was, my lord, deducted. We have no idea about that. Then, my lord, I wrote a letter to them to disclose the details of that house building loan. They did not disclose. Then I filed this writ application. In the writ application, my lord, they have filed the affidavit opposition, where they have, my lord, annexed some documents, that is at page 15. Sanction letter dated, my lord, application dated 12/9/2005, 7,95,000.
Yes.
Till before that, 31st May 2023, they have not intimated anything. Then, my lord, they have annexed A3, page 17, that with the above mentioned title deed relating to the property covered thereby were deposited at the office 9/11/2005 by Sri Tapati Banerjee. Tapati Banerjee stated that he did not with intent to create a security in respect of that property comprising all lands and building, structure, etc. And that deed was not disclosed. My instruction is, in my reply, I have said I have never executed any deed. And what to speak of about the deposit of the same. Then, my lord, kindly come next page. The branch manager, I have written a letter that this is to place on record that we have deposited with this day with you with the presence of 2 other officers employed so and so to the above address, the above noted title deed with intent to create a security in your favor by way of mortgage by deposit of title deed as contemplated section 58A of the Transfer Property Act in respect of such and such, covered by and this is the Subhashini Koikhali survey part, covered thereby comprising all lands, buildings, structure, erection, fixtures, fittings thereon, and all rights and appurtenance.
So admittedly you deposited. Admittedly you deposited the deeds.
If that be so, my lord,
That we so that's your you
and-
have signed.
And they have stated that account was NPA. If it is NPA, when it was NPA not disclosed, and they have not taken any steps. If that account deposit, title deed is deposit, they can realize that money by selling, because I know I have not executed any deed. If they say they have the title deeds were deposited, they realize it from that property. But I specifically stated in my reply that I have not executed any title deed. It is absolutely, my lord, then, my lord, they have written a letter to the police authority. My lord, kindly see. Next.
No,
page.
this account was not a security. This account was not a security to that.
This account was not, and if the 2005 loan was disbursed, and 2023 they have asked for realization straight away without any intimation prior to that. 32,000 they have deducted from that account. And at present, my lord, after filing the deed application, no amount was deposited. My lord, so far I went to the collector office, they said we have sent it to the bank, but they have not transferred to my accounts, and because subsequent statement they have not annexed with that affidavit opposition. Then, my lord, they have wrote a letter to the police authority. My lord, kindly come to page A4. The branch manager, United Bank of India, Koriapukur branch. Letter written by the Assistant General Manager. You are aware of the recent investigation in this respect of serious irregularities committed in some United House loan for the branch. In case of loan account number so-and-so, Srimati Tapati Banerjee, it has been established that multiple finance has taken place. The competent authority has advised to file FIR against Srimati Tapati Banerjee and the concerned promoter, and also to initiate appropriate recovery measures in respect of the house loan account of the undernoted borrower. The serial number so-and-so borrower was there, my lord. What I don't know what they have typed. You are therefore requested to file FIR against the Tapati Banerjee and the concerned promoter immediately and initiate appropriate recovery measures in respect of the other loan accounts. That is, later was August 2010. Then they have, my lord.
But Mr. Rai, they have a general lien, banker's lien is there on your other accounts also.
No, but
you have to then disprove this. These documents are there.
Well, that, my
apart
lord,
from the pension, yes, pension part, I'll ask Ms. Roy Chaudhary what is her stand. But apart from that, the other, they have a general lien.
yes, but it has, if they
Not
have,
necessarily they have to file a recovery proceeding and then utilize your properties for getting the money. No, they have a general lien also if there is any other account with the bank. Under the Contract Act, they have a general
they have,
banker's
they have,
lien.
yes, but not with my pension. That is, my lord.
No, pension, yes. Pension, you are right.
Not with my pension, because it is my only source of surviving. And
Very
the
good.
last 6 months, my lord.
I'll confine myself to pension part only.
Yes.
I'll ask them that. Take a seat, please. Yes, yes. Pension.
Lordship, we may kindly turn to page number 13, Your Lordship,
Opposition.
Of my opposition.
Yes.
Lordship would see that in the middle part, Your Lordship, it's difficult to find out. Lordship, on 31st of May 2023, my lord, an amount of rupees 32,000 was debited, which is their case, Your Lordship. Before
Yes.
that, just 3 to 4 rows back, Your Lordship would find that on 27/6/2023, there was 0 rupees. Right side, my lord, it is written that NPA recovery. My lord, we have not recovered. My lord, what has happened when only the pension amount was being credited in that account, we could not recover, because we cannot attach the pension. We cannot recover from the pension amount. Only in the month of April, Your Lordship, some amount from other sources were also deposited in the account, which is there.
Those
page
two
number-
amounts only.
Lord,
Two amounts.
Two amounts.
Yes.
Since there were other amounts deposited in that account, thereafter we have initiated a recovery and we have deducted rupees 32,000. Prior to that, even the account was an NPA. We couldn't recover. We did not try to, because there was no other fund other than whatever the amount of the pension.
Up to now, you have deducted only 32,000.
Only 32,000.
One single instance.
Once, because there was only two transactions which has happened in the month of April. Thereafter, in the month of May, my lord, an amount of rupees 32,000 was recovered. My lord, thereafter, what the petitioners have done, they have not added the Foriapukur branch, which is at present the Shambazar branch as a party, because amount was debited by them. Lordship, I have the statement of accounts which is there in page number
25.
I'm so sorry, Your Lordship. Lordship, which is there in page number 25.
Yes.
Lordship will see that on 31st of May 2023, amount of 32,000 was debited. My lord, I say that intentionally this branch was not made a party, because the entire loan and the transaction, my lord, has taken place from this bank, and that is why this bank has not been made a party. It was not disclosed. It is also not the fact that the husband of the petitioner has taken a loan, my lord, from the annexures.
She herself has
taken a loan. My lord, how can they dispute that they have not taken a loan? It is their signature, it is their document. And my lord, we have initiated a complaint before the police also, my lord.
What is the role of Dhakuriya branch? They have impleted Dhakuriya branch.
They have impleted Dhakuriya branch because the pension amount is being debited to the Dhakuriya branch, and the bankers lien, my lord, it is applicable to all the branches. My lord, it is Punjab National Bank as a whole. Lordship, that is why when
I'll restrain you from deducting their pension accounts which come in month by month.
Lordship,
The pension amount.
amount.
Sorry. Only that. Apart from that, whatever else you can take.
Lordship, if there is any other amount, my lord, the bank has the right.
Yes, you could have recovered more than that actually. The two amounts which have been
Nearly 1 lakh.
Bank has been
nearly 1 lakh. They could have taken. They should have taken that.
They should have.
bank has been fair this time.
No. What
They have
people are-
deducted only
people are-
one amount.
Foriapukur
My lord,
branch
because
never-
thereafter there was no other amount which has been credited.
Foriapukur branch never wrote a single letter since 2000.
why-
I'll make this clear,
Not
Mr. Roy and Ms. Roy Choudhury. I'll make it clear that whatever amount has been deposited as reflected from the statement of account in lieu of their pension or interest on that pension, some 100 to 200, that amount will not be touched by you. That they will be entitled to operate. Apart from that, whatever is there and whatever comes in, you will be entitled to use your exercise your lien. The dispute in the present matter is short. First up, learned counsel for the petitioner contends that the petitioner was unaware of depositing any title deeds with the bank in connection with the alleged loan pleaded by the bank. First up, however, the bank started deducting an amount which is equivalent to the pension of the petitioner. First up, it is submitted that the account from which the same was deducted is actually the pension account of the petitioner. First up, learned counsel cites the analogy of section 60 of the Code of Civil Procedure and the general principles of law that pension cannot be attached. First up, next para, learned counsel appearing for the bank points out from the statement of account annexed to the affidavit in opposition that only a single instance of deduction of rupees 32,000 finds place at the behest of the bank. First up, it is shown from the accounts that amounts other than the pension of the petitioner have also come in the said account. First up, next para, that apart, learned counsel for the bank also places reliance on a communication dated August 21, 2010 to the branch manager of the United Bank of India, Foriapukur branch, with which the petitioner had a loan, indicating that an FIR was to be lodged against the petitioner due to the irregularities regarding multiple finance done by the petitioner. First up, next para, it is argued that the Foriapukur within bracket now Shambazar bracket close branch of the respondent bank has intentionally not been impleaded, since the loan was taken by the petitioner from the said branch, whereas the Dhakuriya branch is the particular branch where the account in question of the petitioner is held. First up, learned counsel for the bank submits that the bank can exercise general banker's lien across its own branches. First up, next para. Careful scrutiny of the documents on record indicates that there are two instances where amounts other than the pension of the petitioner or the interest thereon have been deposited in the concerned account lying with the Dhakuria branch. Full stop. Next para. The bank, comma, up to now, comma, has deducted only an amount of rupees 32,000, which transpires to be lesser than the cumulative sum of such other deposits. Full stop. Next para. Two propositions in the present matter are well settled in law. Full stop. First, that the banker has a general banker's lien on accounts held with it in the event a debt accrues in favor of the bank. Full stop. Secondly, comma, the pension account of a person cannot be attached. Full stop. Next para. Construing the said two propositions harmoniously in the facts of the present case, comma, it will be open to the respondent bank to deduct amounts which have been deposited in the concerned account of the petitioner over and above the amounts which are deposited in lieu of the petitioner's pension or interest thereon. Full stop. Next para. Accordingly, WPA 23671 of 2023 is disposed of by restraining the petitioner bank, by respondent bank, from deducting any amount in lieu of alleged unpaid loans by the petitioner from the account in question over and to the extent of the amount deposited therein by way of the petitioner's pension or interest thereon. Full stop. It is, comma, however, comma, made clear that the bank can exercise its banker's lien across its own branches in respect of the amount which is deposited in such account over and above the pension of the petitioner and or the interest accrued thereon. Full stop. Next para. However, comma, it is further clarified that this court has not entered into the allegations and counter allegations regarding the default made by the petitioner, and it will be open to both parties to canvass the same before appropriate forums. No orders to cause urgency.
And arrear pension, if any, pensions and
যেখানে পেনশন বললাম লাস্টের দিকে ডিডাক্ট করতে পারবে না, পেনশন এন্ড এরিয়ার পেনশন, না পেনশন হাইফেন কারেন্ট অর এরিয়ার. Yes. Sorry. Next. 13.
Yes, Your Lordship, I am appearing for the petitioner.
Yes.
My Lord, this is in respect of a writ petition where, my Lord, high tension line was erected by the authorities concerned.
You are for the state. Yes.
Now I am praying for, my Lord, adequate compensation in accordance with law. My Lord, representation was sent. If Your Lordship kindly.
The project is complete.
Yes. Line has been installed. My Lord, so far the photographs which has been given by my
compensation we cannot decide, they have to decide. So yes, what do you say, Mr. Paja?
It is just
under the provision of Telegraph Act, they are entitled to compensation after compensation job.
So I'll direct you to act on the representation and assess the compensation within what period should be reasonable. Tell me.
Yes.
What period should be reasonable? 1 month.
Yeah,
1 month.
Very well.
The limited.
Just represent
Yes. Limited grievance of the petitioner is that the petitioner suffered damages due to installation of high tension electricity supply over the land of the petitioner.
Entire land.
Full stop. Next para. Learned counsel for the petitioner submits that despite representations, comma, compensation has not yet been awarded to the petitioner. Full stop. Heard learned counsel for the parties. Full stop. The petitioner is entitled to compensation for damages done to the petitioner's property due to any work undertaken by the respondent licensee. Full stop. Next para. In such view of the matter, comma, WPA 24056 of 2023 is disposed of by directing the, your D or T now in this? T. Directing the
3 and 4.
WSETCL to as which respondent should I direct? Mr. Paja, tell me. I'll direct. Superintending engineer or assistant?
Assistant is also there.
Still directing the respondent numbers 3 and 4 to ensure that upon a hearing being given to the petitioner and upon scrutiny of the relevant materials, comma, the petitioner's claim for compensation is decided upon as expeditiously as possible and in accordance with law, comma, preferably within 1 month from date. Full stop. After such assessment, comma, if the petitioner is found to be entitled to compensation, comma, it will be the said respondents shall ensure that the compensation is disbursed to the petitioner at the earliest, comma, preferably within a fortnight thereafter. Full stop. In the event the petitioner is aggrieved with the quantum or non-grant of compensation, if any, comma, it will be open to the petitioner to prefer an appropriate challenge against the same.
Only for abandoned.
Yes, Mr. Maja?
I was thinking, I was speaking to my junior.
More than 1 month?
Because of election, most of the times they ask my.
I'll give you 2 months. 1 month or 2 month code. I'll give them 2 months.
And my lord, liberty to communication of the order to the authorities.
Mr. Paja is the communication.
Yes, grateful.
He himself is the communication.
My lord,
yes.
Absolutely.
Thank you.
14 and 15.
14, 15, yes.
My lord, I am for the petition.
Oh, yes, yes. What is the matter?
My lord, last, my lord,
I need
28,
to appear for the state.
Right.
my lord, 28 March, my lord, lordship was pleased to pass an order, and I have complied with the order, my lord. This is my review service.
Key order.
রিপোর্টটা দেওয়া আছে।
Water pipeline, yes.
My lord, they have, my lord, installed the pipelines over my Bastur line, my lord.
Inspection, you have filed a report.
Just now I got this report, my lord, which says this pipeline is being laid outside the boundary wall.
Have you given a copy to them?
Yes.
Now?
Yes.
Right
No, I got it just today.
Deal with it, Mr. Have to deal with it.
On the second page, my lord, will find.
My lord, they said, my lord, what my learned friend submitted right now, my lord.
Hmm.
They said that outside the bound line.
Hmm.
My lord, it is, my lord, over my Bastur line.
That
Without
cannot be
permission.
That cannot be decided by the read code. That is the difficulty.
There is also a suppression.
What?
2010 suit filed against
Don't be
Panchayat
so
of-
dramatic. This is not a
That
jury.
is different part.
This is not a jury. Don't be so dramatic.
My lord, in
What
that,
is the suppression?
my lord, I got two reports, one from the authority which has laid the pipelines and one from the police authority, and police authority's report says about the dispute between them and the Panchayat authority. And the first report which says it's the pipeline which has been laid is on the road of Panchayat. So that has not yet been decided. There is a civil suit pending since 2010 against Panchayat authority.
If the civil suit is pending, Mr. Devnath,
Yes, ma'am.
that's a suppression.
Not pending. Not pending.
Not pending.
No, not pending. It's ex parte order.
Ex parte order.
Ex parte dismissed.
No, in favor of.
Your suit dismissed.
In favor.
In favor of.
Where is that? Why did you suppress that?
No, I have stated.
Has that been stated in the writ petition?
Yes, ma'am.
Yes.
Where? Which paragraph?
ওটা বল। আমরা পিটিশনে বলেছি pending?
কোথায়?
Well, give me some time.
Will parent.
পিটিশন অ্যারেস্ট করিস নি কেন?
Ex parte what degree has been passed? Writ petition, why should the writ petition not be dismissed for suppression of this fact? Mr. Devnath, satisfy me on that.
Yes, submit to Lordship, my lord. Because in the petition itself, as per my junior instruction, my lord, petition itself, my lord, has stated in the petition.
Apparently, his instruction is wrong. I don't find it from the averments. You canvass your rights in the civil suit, Mr. Devnath.
My lord, then my lord, kindly take this matter, my lord, tomorrow.
No, no.
Because, my lord, may I submit
What
to-
ex parte degree is he saying? You got an ex parte degree against the Panchayat?
as per instruction of my junior.
No, my lord.
Because
It's a private dispute. It's a private.
this is, my lord, the suit was only for the, as per instruction, my lord, this is a private suit. It's a private dispute. not against the government.
The report filed by the state respondent be kept on record. First of it transpires from the same that the water supply line in dispute was installed for public benefit. First up, it has been stated that as the existing road is outside the existing boundary wall and the road is used mainly by local people of the village, comma, there is no way to ascertain that the road is a private land instead of Panchayat road. Full stop. That apart, comma, learned counsel for the state files a written instruction and submits that the writ petitioner is guilty of suppression of material facts.
Kindly issue any learned counsel make the proper.
Insofar as a suit is pending between the petitioner and the Panchayat regarding the self-same land which has not been disclosed. Push up next para. Learned counsel for the petitioner submits on instruction that the suit is between private parties and that the same has been decreed ex parte. Full stop. However, comma, a serious question arises as to what prevented the petitioner from disclosing such facts in the writ petition itself. Full stop. Be that as it may, comma, the writ petitioner is directed to file to produce all necessary documents pertaining to the said suit upon serving advance copies thereof on the learned advocate for the state on April 8, 2024, when the matter shall be listed.
That is what I'm in Apex code, my lord. Kindly, my lord.
Apex code? Then I'll fix it on that date only.
That, my lord.
We'll be honored if you are not here in the Apex code.
Only, my lord, kindly make it 11th, my lord.
Very well. On April 11, 2024, for passing further orders. The instruction, written instruction and report filed by the state be kept on.
I'm grateful. I'm grateful. My lord, time
Yes, you also please try to get hold of those suits or what happened to that. Please ascertain, try to ascertain.
I will.
If the Panchayat is a party, you can ascertain.
My lord, next matter, item number 15.
Again, suppression.
Yes, no. I have already stated in paragraph 5. Kindly see page number 5.
We'll take the matter matters together.
Kindly see one document.
No, we'll take them both the matters. Both are connected matters.
Both are connected, same matter. Only, my lord, I am drawing kind attention to my lords.
No.
Kindly
I'll
see,
take up together. No.
Photograph. My lord, this is a photograph.
I'm not interested in a
Without,
photograph.
my lord, having any LA case. Having any LA
Mr.
case.
Devnath, you must know when to stop. This is not the Apex Court. We are very afraid of you. So please stop here. Go to the Apex Court, come back, hone your skills further, and then we'll hear both the writ petitions together. Next matter, please.
16.
Yes.
Petitioner, my lord. The petitioner applied for one electric connection, my lord. Subsequently, my lord, the quotation, my lord, given by the office, my lord. Thereafter, same was my deposited, my lord. Thereafter, my lord, electric officer informed me that, my lord, there is no way leave, my lord, to give connection. After that, my lord, I made a representation with the rough sketch map, my lord. There is a way leave, my lord, through the government road, my lord. Till date, my lord, the connection has been not given to me, my lord.
My lord, as per my instruction, lordship.
Your permanent residence is Hollywood. Omar Sharif. Yes, what is it?
Lordship, as per my instruction, lordship, this new connection would be effected by the 20th of this month, lordship. There was a way leave problem. That is the.
There was a
way leave problem. There was obstruction from other.
Now it's.
Yes, lordship, it has been resolved by 20th of April. As per my instruction, this would be effective.
Right. I'll record.
Give direction to like they will give the connection as soon as possible within my lord.
By 20th, I'll put it in my order.
Lordship.
Learned counsel for the petitioner submits that the petitioner complied with all formalities after applying for fresh connection, but such new electricity connection has not yet been given. First up, learned counsel for the WBACDCL submits that there were certain way leave issues due to resistance in the locality for which the connection could not be given till now. However, on instruction, learned counsel for the WBACDCL assures that the connection shall be positively given by April 20, 2024. Full stop. In view of such fair submission on the part of the WBACDCL, WP 828908 of 2023 is disposed of by directing the WBACDCL to positively give the new electricity connection to the petitioner on or before April 20, 2024. No address to cause certain certificate.
17.
Yes, Mr. Banerjee, now notice given.
My lord, the pension has been short.
Yes.
Lord, it is the case, the freedom fighter's wife, widow, she is claiming the pension, family pension.
Right.
Under the scheme of the Swatantra Sanman Sainik scheme of 1980. When I was alive, petitioner was alive. He was
still alive.
He was living.
Your husband was alive.
Husband was living. He was provided with the pension payment order, and he died in the February. I have annexed the death certificate at page number 25.
Was pension given to him at any point of time?
Yes, yes, long time.
No,
From
this is a
it
matter
is
your lordship knows there are stages by which time application is to be made. He has applied after 6 months. Your lordship direct the authority to consider and dispose of within a certain period of time.
at the same time, my lord, it may be from my
Mr. Bhattacharya, there is no.
It's a joint application has been made, but and he's claiming alone, my lord.
is
Your
the-
lordship kindly
only legally.
yeah.
Mr. Bhattacharya, there is no absolute bar if she files after 6 months.
As such,
You can consider.
consider and dispose of if my lord entitled, they will pay. Right?
What is the joint?
My lord, your lordship.
By whom? Petitioner is the widow, and by
Petitioner is the widow, petitioner number 1, and other are the major sons of the
First
deceased.
title, your lordship.
major sons are not entitled.
Not entitled.
First
But
title,
only
your lordship. They will
sorry.
consider everything.
only to show my prayer is that to disburse the pension amount, family pension to the dependent. Only petitioner number 1, wife. Nothing
If
else.
she is otherwise entitled, then she will provide all the documents before the authority if
already-
ask for.
only-
They are
What will be a reasonable time, Mr. Bhattacharya?
6 weeks.
Only
In view of the election, otherwise.
Fair
I am
fair
73 years old.
You are?
73 years old.
Right.
And now it is. My husband was receiving the
Mr.
pension
Banerjee need not say whatever you studied.
only.
You have got your release.
Only, my lord, if any extra payment is received by me,
Extra payment?
suppose after the death, I find from the bank statement some extra payment, I will sacrifice that, I will refund it.
So,
Subject to
extra
the
payment to whom? Mr. Bhattacharya or
No,
the
no, extra
official
payment.
there or
Pension
to
came-
the highermost authorities?
Pension came in the name of the deceased, and for 2 months at least, that has been withdrawn.
The petitioners
Undertaking is to
claim,
refund it.
the petitioners submit that the petitioner number 1 is the widow of a deceased freedom fighter who was getting freedom fighters pension under the Swatantrata Sadhinata Sainik scheme, Samman scheme. Full stop, next para. When the petitioner number 1 applied for getting such pension on the demise of her husband, comma, the same has not been acted upon by the respondent authorities. Full stop, next para. Learned counsel appearing for the respondent authorities contends that the petitioner number 1 filed her application after 6 months. Full stop. However, comma, in his usual fairness, comma, it is submitted that the respondents shall consider her application in due process of law within the confines of the scheme and decide on the same within an outer limit of 6 weeks. Full stop, next para. It is also pointed out that the major sons of the deceased freedom fighter have also preferred the instant writ petition, although they are not entitled to the scheme. Full stop, next para. On a cursory perusal of the cause title of the writ petition, it is evident that petitioner numbers 2 to 4 have been added in a redundant manner, comma, since being major sons of the petitioner of the freedom fighter and not entitled to the maintenance, comma, they were not required to be implemented as parties. Full stop. However, comma, superfluous misjoinder by itself is not a ground for dismissal of a writ petition. Full stop. Accordingly, since the petitioner has applied for such pension as indicated above, comma, the respondents are required to look into the same expeditiously. Accordingly, WPA 2454 of 2024 is disposed of by directing the Chief Secretary or Deputy Secretary?
Deputy Secretary,
Under Secretary.
The Ministry of Freedom Fighter, my lord, Under Secretary, and here, my lord, the authority is, my lord,
Deputy Secretary and the Chief Secretary of the state. Chief Secretary of the under the scheme.
So, Bhattacharya, whom should I?
I am giving the scheme, my lord. This is the.
You tell me from the scheme, read out from this.
Yes, my lord. My lord, pensions who the persons who
Freedom
consider
Fighter
themselves
Sale Act থাকে না?
and how to apply there is persons who consider themselves eligible for Sanman pension under the scheme should apply in duplicate on the prescribed application form. One from duly filled and supported by the
Mr. Bhattacharya, let him continue. You submit it.
document as proof of the claim
You submit in the meantime. Let him continue.
of suffering
But I
should be sent.
Lordship, my lord, the authority, the undersecretary will consider if they ask for any document, any clarification
No,
from the
no.
state authorities, they will
If I direct the undersecretary, it will be easier, quicker for him.
My lord,
But it has to go through here.
Here, my lord, they have made, my lord, comprehensive application. One copy, my lord, both undersecretary and the state government.
My lord,
That
it is
a
written in the
big problem.
Chief secretary is the, you say the chief secretary is the,
State. Here, my lord, your lordship will find district magistrate representation, your lordship, please.
No, no, my lord, my lord. Let me.
by directing, যেটা বলছিলাম continue করুন, by directing the respondent number 1, that is the chief undersecretary, Ministry of Home Affairs, Freedom Fighters Division, and the respondent number 2, the chief secretary, State of West Bengal, to consider the application of the petitioner within 6 weeks from date, and to decide on the same in accordance with the law and the concerned scheme. Push up immediately thereafter, comma, the said respondent shall communicate the outcome of such decision to the petitioner in writing.
Lordship kindly, district magistrate, your lordship kindly consider, my lord.
As well as.
Whom should I direct? District magistrate?
Yes.
My lord, it is home.
As well as 1 and 2.
1 and 5, my lord. But I am speaking from the representation of the petitioner. Your lordship kindly peruse.
I'm not speaking, I'm reading from the scheme itself. Scheme says that, my lord, that is why I'm.
6 is district magistrate.
I'm showing the scheme, my lord. Better, my lord, go by the scheme, my lord. If it is possible, my lord, respectful submission. My lord, kindly see.
This is verified by the district magistrate.
My lord, kindly see the body is mentioned in the scheme itself. I'm carrying with the scheme so that the any unnecessary time will be killed. My lord, how to apply? Kindly see the bottom portion. That is Chief Secretary of the concerned state government, public union territory, administration, and the secretary. The second copy should be sent to the deputy secretary to the Government of India, Ministry of Home Affairs.
This is
Instead of deputy secretary, if joint secretary is, according to him, is the concerned respondent.
No, deputy secretary and chief secretary of the state.
Yes.
That is the
Deputy secretary of the
union.
Ministry of Home Affairs of the union.
তাহলে না, যেটা আপনাকে বললাম ওই
The party is there.
undersecretary
To the, as per my learned senior friend.
This is done by my undersecretary.
Undersecretary.
The scheme says these two people.
Yes.
Whatever steps.
All other
No, no.
matters, my lord, your lordship is.
They will consider and they will send to the undersecretary. Yes.
Gratefully,
Colonel.
grateful.
Several order passed by your lordship, all. to the
Undersecretary,
and
yes.
Even content file.
But the scheme says otherwise. I should recall those orders.
Something new, my lord.
Yes.
Grateful.
18.
18, who is there?
Samjiju.
Well, I'm for the petitioner, my lord.
I'm the state respondent.
Well, I'm for the distribution license. Well, there's a, my lord, there's a private respondent as well, my lord. I've served a copy. Received.
Good service?
Good service, my lord.
Yes. What is the matter? What is the matter?
My lord, the petitioner, my lord, has applied for electric connection in respect of a premise. Now, my lord, admittedly, there are 2 deeds of conveyance. One is of 2015, another, the private respondent shows that he has a deed of conveyance of 2020. Now, my lord, if you look at the schedule, my lord, the schedules are different. So far as, my lord, I claim that I have a, my lord, my premises, the area of my premises, more than 2, my lord, kindly, my lord, takes up page 20, my lord, the schedule. 2 katas is, 2 katas, 8 chitaks is my premise. They say they have 9 chitak. My lord, I have annexed both the deeds. Now, my lord, I have applied for a electric connection.
Apart from this, do you have any possession proof? Apart from the deed?
My lord, proof of possession, otherwise, my lord, record of rights, my lord, it stays in the name of my lord, the predecessor.
Record, not record of right. Some other, your residence there has to be shown by anything.
But I have a premise, my lord. I have made complaints to the police authorities.
Occupation is necessary.
My lord,
There are conflicting sale deeds. So your occupation is required to be shown by.
conflicting sale deeds, my lord. Kindly considers, my lord, the areas are different.
I appreciate, but exactly which area you are in possession of, that cannot be ascertained like just like that. But you mean to say that at least some portion you are in.
At least at some portion I am there.
Yes, what is the objection?
Now, my lord, the objection, my lord, they have.
Objector is who is the other purchaser is the objector.
No, my lord. I have, my lord, applied for a connection. My lord, the authorities have told me that you go and change your ownership. there's already an existing meter.
Change your of the meter.
Change ownership of the existing meter. My lord, annex that letter as well.
Meter is in the name of the vendor.
Letter is in the meter is in the name of the vendor. The existing meter. The existing my lord, excellent. The existing meter is in the name of the private respondent. They say that you go and change the ownership of
Private
that meter.
respondent is also owner of one of the portions.
Even if, my lord, if we consider that the deed of the private respondent is, my lord, legitimate, then also, my lord, he is the owner of only 9 chitaks.
Even then, you cannot get his name changed in your.
My lord, I do not want to. I applied for a new connection.
But you are unrelated otherwise. Private respondent.
Otherwise, absolutely unrelated.
Yes, what do you say?
My lord, he applied, quotation raised, our main my lord inspected the premises. Upon inspection, it has been found that, my lord, there is one existing meter and he has been using electricity from that meter.
How do you ascertain that?
My lord, that upon inspection, it was found. This is my specific instruction. And my lord, accordingly, my lord, several letters have been sent. Firstly, my lord, he was intimated that.
But he's an independent owner by virtue of a different sale.
Yes, but he is using. And, my lord, we contacted the erstwhile owner, whose name the existing meter is, my lord, is there. My lord, he has expressed that he is not willing to, my lord, give no objection for change of his name. He has applied, but he has submitted the form without the signature of the erstwhile owner or in whose name the existing connection is there.
Look, existing connection, he need not produce a
procure. As per our rules, my lord, you'll notice, my lord, in a premises, my lord, if there is an existing connection, my lord, and my lord, we have inspected, we have found
not necessarily. The rights have to be different.
Yes, my lord. Now
they have no nexus. They don't have any. They're different.
My lord,
He's wanting a new connection. Given
title suit is also pending in respect of, my lord, that property with other person. This not the private respondent. And, my lord, he has also written in his, my lord, writ petition that he has been advised to file another suit, my lord, against the private respondent regarding this dispute, because the private respondent is claiming that he is the owner of the property and he has, my lord, because, my lord, in our database, his contact numbers and details are with us. We have contacted over telephone. He has said that that is his plot of land and the existing meter is in his plot of land, and he is not willing to change it or my lord, assign it to his name.
No question of assignment. He cannot apply for somebody else's name being changed in his name.
But, my lord, as per our record, my lord, the premises, he is.
I'll hold that, Mr. Bandapati, I'll hold that he is claiming on the basis of a separate sale lead from the private respondent. Therefore, he has no nexus insofar as the electricity.
But, my lord, as per my instruction, this is same premise.
Premise may be same, but the areas are different.
Lordship, kindly, Lordship, takes up the schedule of both the deeds, Lordship. Page 20 is, Lordship, my deed.
And your deed is of 2016.
My deed is of 2015, my lord.
And the other person's is of
2020.
Then in any event, he has prior right.
No, but he has purchased from other person, not from the private respondent. Private respondent has purchased
not from private. Both have purchased from the same vendor.
No.
Prime facie proof of possession is there.
But, my lord, this is my specific instruction that he has been using electricity from the existing meter. The same premises.
Yes, what do you say to that?
My lord, no, my lord. I have do my lord.
What were you doing so long? If you
my lord, kindly, takes up.
You are living without electricity.
My lord, page 62, Lordship, only takes up. Page 62 is their letter. They have given me the letter stating that only change of ownership procedure A 2010. My lord, no such allegation has been, my lord, pointed out.
No, my lord. He has not annexed the relevant.
What is that?
And, my lord, only one more thing, my lord, I want to as well.
This is, my lord, 6 July 2023. It was sent to him that there is an
existing service connection. You have said here also.
Proof of position.
Here also you have stated. Page 62 also you have stated existing service.
Yes. Existing service, existing connection on same holding number.
And, my lord, so far, my lord.
And, my lord, to resolve the dispute, my lord, it was subsequently advised to him that you better make an application for change of ownership, because he is claiming that he has purchased the property. Now he is the present owner of the property.
Change of ownership.
But he purchased previously.
Ownership, my lord.
That's why it was advised.
Change of ownership, how can it be done? How can he apply for change of ownership? There is an existing connection. That person is saying, I am in connection.
What he has submitted before the office, that he is the present owner, and he has purchased from the erstwhile owner. The meter is existing from in the name of the erstwhile owner. So it was advised you better change the name. then we have no
Give them a
objection.
My lord, kindly, and my lord, so far,
Same holding, same premises number, my lord, the existing meter connection is there and he has been using, it has been found upon inspection.
my lord, so far, my lord, only proof of possession, my lord, kindly takes up page 72 once. My lord, there's a title suit, my lord, as my lord, senior friend pointed out, with others. My lord, the learned trial, there was the learned trial court in my lord, my application, in my lord, my status quo, my lord, injunction application order, my lord, has specifically, my lord, stated that I am in possession.
This is what I was asking you. The petitioner contends that, despite service, none appears for the private respondents. Affidavit of service filed today be kept on record. The petitioner contends that the petitioner purchased the vast majority of the property in question in the year 2015 by a registered sale deed, which is annexed to the writ petition. Full stop. In the year 2020, apparently the private respondent also claims to have purchased a minuscule portion of the same property. Full stop. It is contended by the petitioner that the petitioner is in occupation of the property and sought electricity connection. Full stop. However, the WBSCDCL has raised an objection on the footing that there is an existing service connection at the premises found in use by the petitioner, and the petitioner has to apply for change of name in respect of the meter. Full stop. Next para. Learned counsel for the WBSCDCL contends that the WBSCDCL found on inspection that the petitioner himself has been enjoying electricity from the existing connection, which is in the name of the private respondent. Full stop. As such, for the same premises, a different connection cannot be given. Full stop. Next para. You are wanting a service connection.
My lord, new residential
Service connection to service connections cannot be difficult.
Domestic connection.
Domestic connection, my lord.
But that will be from the same.
Yes. Same premises, same meter.
Next para. It transpires from the documents annexed and the submissions of parties that the petitioner holds a purchase deed which is prior in point of time than the private respondent. Full stop. As such, it cannot be gainsaid that the petitioner has a prima facie better title than the private respondent in respect of the property. Full stop. Moreover, the petitioner has obtained an order of injunction against third parties within bracket, not the private respondent, bracket closed, in respect of the self-same property from a competent civil court, which is annexed at page 72, bracket, annexed at P7, bracket closed, of the writ petition. Full stop. Such injunction order prima facie shows that the petitioner is in occupation of the property. Full stop. Even the WBSCDCL is not disputing the occupation of the petitioner, but raises a question as to whether two different connections can be given at the same premises. Full stop. It is also the allegation of the WBSCDCL that the petitioner himself has been using electricity from the existing meter. Full stop. Be that as it may, there is no direct nexus between the petitioner and the private respondent, inasmuch as they claim title to the property in question on the basis of different documents altogether. Full stop. Hence, the claim of title and possession of the petitioner is independent from that of the private respondent. Full stop. Hence, there is no reason why a metered connection cannot be given to the petitioner independently in the name of the petitioner from the existing service connection at the premises in question. Full stop. Next para. It is, however, obvious that such connection, even if given, cannot create any special right or equity in favor of the petitioner, which the petitioner otherwise does not have in law. Full stop. Next para. The contention of the WBSCDCL as to not being able to give a new connection to the petitioner because the petitioner is using electricity from the same premises is negated by the fact that the petitioner claims an independent right from the private respondent with respect of the in respect of the property. Full stop. In such view of the matter, WPA 5238 of
just a minute. That will be against our rules because in the same premises, but I don't know how much.
If it is a service connection, it will be against your rules. But if it's a metered connection, it is not against your rules. Your only point could have been splitting of load. which I have cut here.
Yes, no, but my lord, the existing meter, I don't know, my lord, from that meter, my lord, the portion of the premises which has been occupied by the petitioner, except that, or my lord, in addition to that, any other portion of the plot or the, my lord, the premises is being, my lord, electrified from that meter, and that has been used by the private respondent, or that I don't know. That is that regarding that, my lord, I don't have any instruction. No, my lord,
Wherever is the
but
present
my
meter
lord,
is.
since they are using the electricity from the existing meter,
Yes.
then, my lord, that is to be cut from that. Their connection is to be cut from that meter, and
Why should that be cut? If they apply for disconnecting, then only cut. He has no right to ask for disconnection.
but, my
of
lord,
whatever-
he has
No.
been using, means, my lord, he has connection. He has connection from the meter.
Accordingly, WPA 5238 of 2024 is disposed of by directing the WBACTCL to give a separate and independent electricity metered connection from the existing service point at the premises to the petitioner, subject to the petitioner complying with all due formalities in that regard within a fortnight from such compliance being made. Full stop. If prevented, comma, the WBACTCL shall be at liberty to approach respondent number 6, the officer in charge of the Sonarpur police station, for adequate police assistance, which will be rendered at the cost of the petitioner, comma, if necessary, by removing any padlock or other hindrance to facilitate the access of the WBACTCL. Mr. Bandyopadhyay,
my lord,
if there is an existing service connection which you are admitting in your objection itself, there is an existing service connection, right? There can be two things. Either the person who is enjoying, who is the owner of the meter, he or she can say that I don't want to proceed with this, disconnect this.
my lord.
Then also from the same service connection remains, an independent meter will be sustained.
Yes.
And if he does not say that, in that case also that connection remains. You charge your electricity bills for that connection from the owner. His will be an independent meter. That is the precise reason for which a new metered connection is required to be given to him. Otherwise, he will be entangled with the meter of the other person. He'll depend on the mercy of the other person, whatever he does.
Yes, but my lord, that I don't know whether a separate line is to be drawn.
When your people go, they will know.
My lord, Sonarpur has no jurisdiction, my lord. I have a report, my lord. The my lord, Sonarpur PS has
the
no
PS
jurisdiction.
has no jurisdiction.
Yes, my lord.
Yeah.
যেখানটা রেসপন্ড নাম্বার 6 বলেছি, ওই রেসপন্ড নাম্বার 6 অফিসার ইন চার্জ অফ দ্য সাচ এন্ড সাচ, ওটা কেটে দিন। অ্যাপ্রোচ দ্য লোকাল পুলিশ স্টেশন which will grant appropriate assistance. The report filed by the state be kept on record.
Then, my lord, liberty may be given to the, my lord, WBACTCL, my lord, if during execution, my lord, it is found that, because, my lord, I don't have the complete list.
You have admitted there is an existing service connection, you have to give a new metered connection from that to him. There is nothing to be ascertained.
My lord.
Nothing to be
The
ascertained.
existing connection, a
I've
separate
made that
meter-
clear.
Separate
Metered connection, independent metered connection from existing.
Very good. Grateful.
Come back in 10 minutes.
19.
I am for the petition.
I am for the respondent here.
Yes.
My lord, before taking up this matter, there is another matter filed by the respondent
Lordship,
that
affidavit
is
of service.
appearing in the monthly list 196. That is interconnected between.
What is the matter about?
Lordship, may I submit?
In that matter, we prayed for new connection with the prayer for shifting of the plaintiff's meter to his residence.
And your prayer is for?
Lordship, please.
Their prayer for that it is alleged that we are obstructing the CSC authority to
Lordship,
take
this is
reading
not-
of the.
Lordship, this is second round of litigation. Primarily, petitioner.
Shall the let both be heard together?
Lordship, petitioner is without electricity in the meantime. Lordship.
Monday will not affect
Okay,
you.
Lordship.
Affidavit of service filed to be kept on record. Full stop. In view of the identity of the causes of action, let the present writ petition be listed under the same heading tomorrow, along with.
Instead of
Nothing.
tomorrow, my lord, take it up on Friday.
Why? Come back tomorrow. No.
Tomorrow I have got some difficulty.
No, Mr. Mukesh, not in every matter. No.
Well,
Tomorrow.
No, tomorrow I will.
Sir, tomorrow.
First half there is some difficulty.
No,
my lord.
tomorrow. এটা নাম্বারটা দিয়ে দিও ওনাকে দিয়ে দিও give the WP number tomorrow Mr. Mukesh. Yes, next.
20.
My application.
Yes.
The petitioner before your lordship is the widowed daughter.
Please use the microphone.
My lord, the petitioner before your lordship is the widowed daughter of one Purnachand Maiti, who was receiving SS.
Freedom fighter.
Yes, freedom fighter pension. Like after the death of the father of the petitioner, her mother was receiving the pension. Then she died in 2021. Thereafter, the petitioner made the
You have
representation.
been refused on the ground that you are not unmarried.
Lordship, my lord, identical.
Refused
matter
or not being heard.
Not as yet refused, but
That
I
is
want
what
to
I'm
this one
asking.
1 to 3, the Union of India and the officials of the central government. So
No, they've rejected. I have annexed it.
Where is that page?
Yes.
order.
No, no, it is there. It is there.
Which page?
My lord,
Mr. Bhakot is the architect of this
no, not that, but
scheme.
my page 35. And I say P6.
Who are eligible?
This is the scheme.
But the issue is that
Oh, acha, they have, acha, right.
Father, they have to fill twice, unmarried.
Yes, yes, refused.
Includes
my
the mother, father.
I'll direct them to reconsider, subject to
Yes.
hearing your
Unmarried.
reference.
My
I'll
lord.
direct you to reconsider.
Lordship.
I'll say that because it has been consistently held that unmarried includes widow,
Lordship.
but otherwise you have to check whether she is getting any alimony or
Lordship,
because she also have other rights. So
Very well.
I'll hold that.
my lord, rely on a decision of your lordship.
Not necessary.
The petitioner is the widow daughter of a freedom fighter who was getting freedom fighters pension under the Shadhinota Swatantrata Soinik Samman scheme. Full stop, next para. After the demise of her father, comma. Now, after the demise of your father, as well as your mother must be,
Yes,
As well as mother.
as
Now,
well as her, as well as her mother, comma.
Petitioner is widow daughter.
Yes. The petitioner applied for pension under the same scheme in the capacity of such widowed daughter. Full stop, however, comma, by a communication dated by an order dated May 18, 2022, annexed at page 35 of the writ petition, comma, the same was refused, citing clause 3 within bracket the eligibility clause bracket close of the said scheme. Full stop. The contention of the respondents is that under the scheme, comma, unmarried daughters are entitled to the said scheme, but not widowed daughters. Full stop. I'll put something into your mouth. It is further contended that the rights to get the benefit of a scheme are governed by the provisions of the scheme and is not an independent right. Full stop, next para. However, comma, in the present case, comma, the question is not whether the petitioner is claiming a right independent of the scheme, but as to the correct interpretation of the expression double inverted unmarried daughter, which is there in the scheme itself. Full stop. There, I do not find any reasonable line of distinction between an unmarried and a widowed daughter, since the matrimonial status of both are the same. Full stop. The position might have been otherwise if the expression within double inverted spinster daughter was used instead of unmarried daughter in the said scheme. Full stop. Having not done so, comma, the authorities having not done so, comma, it is evident that the widowed daughter who stands on similar footing as an unmarried daughter is also entitled to the same scheme. Full stop. However, comma, there may be a doubt as to whether the petitioner, comma, in the capacity of a widow, is getting any alimony or maintenance from the estate of a deceased husband. Full stop. However, comma, it is for the authorities to ascertain the same upon giving an opportunity to the petitioner of representation stroke hearing. Full stop. However, comma, the impugned rejection merely by citing the eligibility clause is not justified in law without going into the above components of the issue. Accordingly, WPA 6992 of 2024 is disposed of by setting aside the impugned rejection of the petitioner's claim for freedom fighters pension as the widowed daughter of her father, dated May 18, 2022. Full stop. The respondents shall now consider the claim of the petitioner afresh in respondent number 3 shall now consider the claim of the petitioner afresh in accordance with law, comma, upon ascertaining as to whether the petitioner is still a dependent on the estate of her father as a widowed daughter of her father, comma, having no other income from any other source from the estate of her deceased husband. Full stop. However, comma, for the purpose of such ascertainment, comma, the petitioner, comma, a widowed daughter, comma, shall be construed on the same footing as an unmarried daughter under the scheme otherwise. Such exercise, comma, it is expected, comma, shall be concluded within 6 weeks from date and the outcome thereof intimated to the petitioner. In the event the respondent number 3 is of the opinion that the petitioner is entitled to such scheme, the benefit of such scheme, the disbursal shall be commenced in favor of the petitioner under the scheme at the earliest thereafter. However, comma, if it is held otherwise, upon the ascertainment as indicated above, comma, it will be open to the petitioner to challenge the same before the appropriate forum in a properly constituted proceeding. No arrest to cause urgency.
In identical matter, 4 weeks time has been given. No, 6 weeks on
Elections, they are now busy for the elections.
21.
Yes.
On my lord, I picked up and
the respondents.
this is my affidavit of service.
This is also freedom fighter.
No, no,
No, passport.
rejection. My lord,
Passports.
relates to my lord refusal of my passport application. My lord,
Yes.
what happened in December 2021? I have applied for my passport. My lord. My lord, kindly come at page 13.
Good. Page 13.
Page 13, my lord, this is their communication dated April 24, 2023.
Yes.
My lord,
Right.
after skipping few lines, they have, my lord, intimate the reason why my passport application has been cancelled, that charged with criminal proceeding or any arrest warrant, summon pending. My lord, I have annexed the, my lord, entire order sheet. There is a criminal case against me in the year 1997. My lord, my shop was robbed and I was falsely implicated in this, my lord, process.
Have you got a copy of that notification, Mr.?
Yes.
Just please hand over.
My lord, kindly come at page 35. I am on bail by the learned court below.
No, you have to take permission from the jurisdictional criminal
The
court.
jurisdictions are the competent court. As you lordship noted, in many cases,
You have taught me in so many
sir.
cases. You and the learned additional solicitor general and the others, and Mr. Bhattacharya.
Mere pendency of a criminal case, my lord, is not the ground of.
Oh yes, 6F.
6F.
6F, my lord.
2.
6-2F. I'm sorry.
6-2F.
The petitioner contends that the petitioner
My lord,
apostrophe's application for passport was refused on the ground of pendency of a criminal case against the petitioner. Full stop. Learned counsel contends that the petitioner was framed in the case and is now enlarged on bail. Full stop. That apart, comma, mere pendency of a criminal case cannot be a justified ground for refusal to issue a passport. Full stop. Learned counsel appearing for the respondent authorities places reliance on a notification dated August 25, 1993, issued by the Ministry of External Affairs, which makes a relaxation in the regards of Section 6 within bracket 2 within bracket F of the Passports Act 1967, by virtue of which section, in view of pendency of criminal cases, comma, passport may not be issued to a citizen of India. Full stop. Next para. A perusal of the said notification clearly shows that such relaxation, comma, to avail of such relaxation, comma, the applicant has to obtain a permission from the concerned jurisdictional criminal court for leaving the country, and accordingly the passport shall be issued to such citizen subject to such permission being obtained. Full stop. Next para. Even otherwise, comma, section 6 within bracket 2 within bracket small f clearly stipulates that the passport authority shall refuse to issue a passport if proceedings in respect of an offence alleged to have been committed by the applicant are pending before a criminal court in India. Full stop. Thus, comma, the only option open before the petitioner is to obtain a permission as contemplated in the aforementioned notification from the jurisdictional criminal court for passport to be issued to the petitioner. Full stop. Accordingly, WPA 7064 of 2024 is disposed of by granting liberty to the petitioner to approach the jurisdictional criminal court where the criminal case in respect of the petitioner is at present pending. Full stop. Upon such an application being made, comma, it is expected that the same shall be decided within a week from the said jurisdictional court. Full stop. Such application for permission shall be made under the notification dated August 25, 1993, bearing number GSR 570 within bracket capital E, bracket closed, issued by the Ministry of External Affairs, comma, Government of India. Full stop. In the event such permission is granted to the petitioner, comma, the petitioner shall be at liberty to approach the passport authorities who, comma, upon otherwise scrutinizing the passport, comma, if in order, comma, shall grant the passport at the earliest, comma, preferably within a fortnight thereafter.
My lord, may I be kindly, my lord, since the petitioner is a cancer patient, I have annexed the, my lord, medical document. Let my application be, my lord, considered in a sympathetical ground, my lord.
What sympathy?
Since this is, my lord, petitioner is a cancer patient, my lord.
How is that material here?
It is, my lord.
Don't use your disease unnecessarily. That demeans your clients. Cancer has nothing to do with this. That's the law. You have to obtain a permission only.
My lord, my
No,
lord.
don't demean your client like this. I'm not a big believer of demeaning our clients like this. I mean, he may be a cancer patient. He's not different from us. How is that germane for this obtaining passport?
Better treatment, my lord, ought to be required, my lord.
Better treatment, the passport authorities cannot give you that treatment. Call on the next matter. Yes.
22. Please, the lordship.
Yes, Mr. Haldar.
For the petition, it's a new connection for commercial purpose applied.
You are for this?
Applied and inspection was held, but till today they are ready to comply with the.
You are for the CSC or state?
Yes.
Why not given?
Well, they had made an application. We had considered it. We had carried on inspection. Thereafter, we had replied to them on the ground of splitting of load, my lord. Now, my lords, if they are
splitting of load,
my lords, I find that in the writ petition they have not annexed it, my lords.
But no,
and also there is
I'll record their submission. Yes, also there is
no pleading as such, my lords. If I may just hand over our report,
that may be
serve a
given
copy
the
as well.
No, this is a communication given to you.
Yes, my lord, we have
I'll keep it on record. I'll relegate it to the GRO.
My
The petitioner argues that the petitioner applied for electricity connection but was not given the same by the CSC Limited for reasons unknown to the petitioner. Full stop. Para, Learned Counsel for the CSC Limited submits that a notice was given to the petitioner upon consideration of the application of the petitioner and holding inspection to the effect that the CSC apprehends consequential splitting of consumption of units if a new connection is given at the premises, comma, since the premises are already enjoying the benefit of an existing supply, and it is also extremely dangerous to have more than one source of supply. Full stop. Next para. As the parameters of the dispute raised by the CSC Limited falls within the purview of adjudication of the grievance redressal officer under the regulations framed by the WBERC, it would only be appropriate if the jurisdiction of such forum is not usurped by this court, but the matter is referred to such authority. Full stop. Accordingly, WPA 7152 of 2024 is disposed of by granting liberty to the petitioner to approach the concerned grievance redressal officer having jurisdiction to take up the matter with the dispute as raised herein. If so approached, the grievance redressal officer shall decide the issue in accordance with law upon giving opportunity of hearing to all concerned, preferably within 6 weeks from the approach being made to the grievance redressal officer. No address to cause urgency. A copy of the communication handed over by learned counsel for the CSC Limited today be kept on record.
23.
Namta Neil.
Lordship, Mr. Joyanto Samanto for the state, they engage another court.
You are there. I'll take up the
Your
matter.
Lordship, Millard, I am for the petition. I sub copy to all the respondents, Millard.
Yes, what is the matter?
Millard, matter relating to Millard, SDO initiated suo motu proceeding and cancelled the OBC certificate of the petitioner without the decision or opinion of the state state scrutiny committee, Millard. Millard, Lordship knows, Millard, there is a judgment of the Apex Court, Millard, 1994, Kumari Madhuri Patil. And Millard, pursuant to that judgment, Millard, section 8A and 9(2) of the Act was amended. And Millard, 9(2) specifically, Millard, for a moment, Millard, can you come to page, Millard, 17, Millard?
Yes.
Page 17, Millard, serial number 14. Teli Kulu is the page 17, Millard.
Yes,
serial number 45. Teli Kulu is.
Yes. Teli Kulu.
Millard, I am belongs to the Millard, Teli Kulu, Millard. Millard, page 19, Millard. My certificate is, Millard. My certificate is page 28. Page 28 is my certificate.
Yes, Mr. Samanto, what do you say?
Millard, prima facie this writ petition is not maintainable after the 2022 amendment, Millard.
Why do you say that?
Lord, may I hand over the gazette, Millard?
Yes, please.
Kindly come to section 2. Next page, Millard. After 6, may I read it? After 6 and 9 of the West Bengal Such Act, the following sections shall be cited. 9(1) appeal against.
Yes, prefer the appeal.
No, Millard. Kindly see the judgment.
Not absolute part.
Millard, kindly see. Millard, without jurisdiction, that is the. Millard, kindly see the judgment. Our High Court. As the SDO without jurisdiction, Millard, can. December. 2nd December 22. That point was raised.
Without jurisdiction, why did you say? Please repeat before Mr. Samanto.
Millard, without jurisdiction, because Millard, this state scrutiny committee is the authority. Without the
committee has not yet been formed.
No, Millard. No. Millard, kindly come to page. Suo motu SDO suo motu issued proceeding, Millard. Kindly come to page 41. Second paragraph.
My lord, may I say, my lord, I am the private respondent, my lord.
What is your locus standi? Who are you?
He made an application before the.
You made the complaint.
Yes, Millard. On the basis of that.
Your jurisdiction ends when you make the complaint. After that, it is between the authority and him.
My lord, there is only.
You have an axe to grind. File a civil suit.
My lord, only indicate, my lord, the section 12 of West Bengal Scheduled Caste, Scheduled Tribe Identification 1994, my lord. The notification and the rule was framed, my lord, 1995, my lord. The issuing authority can cancel the, my lord, the certificate of the part. Here is the, my lord, rules, my lord, framed by the এটা হলো বাবা এটা ফোর্স ডকুমেন্টস
Our agent notification issuing authority can cancel.
Have you got a copy of the 90? This is the 94 Act.
1996, my lord, the rule framed by the
1994 Act, my lord, Act. is
8A.
8A and 9(2), my lord.
Right.
The issuing authority cancel.
That was amended in the year 2007.
Happy.
Here, was there any case of false information or misrepresentation made?
My lord, I am coming to that, my lord. I am coming to that, my lord. My lord, kindly come to page 19, my lord. Vangsha Talika, my lord. Then I am Vangsha Talika.
No, tell me something.
Yes, my lord.
Why is section 9(2) not independent of 8A?
8A.
8A. Why is 9(2) not independent of 8A? The scrutiny committee has to be there.
Yes.
Let us see this. The state government may by order constitute a committee to be called the State Scrutiny Committee for verification of social status of a person in whose favor a certificate is issued under section 5.
Yes, my lord.
So at the juncture of issuance of the certificate,
Yes, my lord.
State Scrutiny Committee has to be consulted. Agreed. Here is not a case where it is being issued to you. Here it has been issued to you. It is being cancelled.
Cancelled.
Now, 9 does not say anything that it is circumscribed by 8A. How do you describe that?
Including a case where caste certificate
My
has
lord,
been cancelled.
my lord.
Section 8, Section 8.
Section 8, my lord, kindly.
8A,
kindly, my lord,
yes.
kindly.
Including a case
The state government may by order constitute a committee to be called the State Scrutiny Committee for verification of social status of a person in whose favor a certificate is issued under section 5. And my lord, I am placing on judgment, my lord. Two-man committee was formed and my lord, caste certificate was cancelled. Supreme Court, my lord, set aside it.
No, that is
That
different.
order.
I mean,
Three-man committee must be.
let us see
three-man.
this certificate. Mr. Samanth, use your affidavits in this. This request to be
And my
heard.
lord, in the meantime, my lord,
I'll direct you to file affidavit
and
also.
in the meantime, kindly.
I'll stay the
Okay, my
operation.
lord. Otherwise, my lord.
Certain relevant issues have been raised in the writ petition, which require the writ petition to be heard on merits. Push up. Learned counsel for the petitioner argues that in contravention of section 8 capital A of the West Bengal Scheduled Castes and Scheduled Tribes within bracket Identification bracket close Act, comma 1994, comma without formation, without constitution of a state scrutiny committee and consultation with the same, comma this is other backward class certificate, OBC certificate.
Yes, my lord. My cousin brother has
The
OBC
OBC certificate.
My
of
cousin brother and my lord, my nephew has
No,
OBC
then I have
certificate.
a,
My lord, page 19, my lord, kindly come. 1 minute. My lord,
the OBC certificate of the petitioner has been cancelled. Push up. It is argued that section 9 of the 1994 Act is circumscribed by section 8 capital A. Push up. Learned counsel for the petitioner also cites an unreported judgment of a coordinate bench of this court dated December 2, 2022, passed in Chapa Mondol versus State of West Bengal and others, bracket WPA 26675 of 2022, in which the learned single judge had relied on a decision of the Supreme Court in the case of Kumari Madhuri Patil,
my lord, may I-
reported at 1994 6 SCC 241, comma, to argue that in the said judgment, the Supreme Court set out a clear procedure for cancellation of a caste certificate, which has not been followed in the present case. Push up. Next para. Learned counsel appearing for the state submits that in view of the availability of an equally efficacious alternative remedy in the form of an appeal under section 9 of the 9A of the 1994 Act, the writ petition ought not to be entertained in the present case. Push up. Next para. You are relying on?
The private respondent.
You are relying on which?
The rule, my lord, framed by lord, as per conferred, my lord, section 12 of West Bengal, scheduled caste and scheduled tribe identification 1996, my lord. The rule 3, my lord, the issuing authority can cancel the, my lord, prima facie, my lord, if it is found that there is a discrepancy in the obtained the certificate, the issuing authority can cancel the order.
Learned counsel for the private respondent places reliance on the rules framed under the 1996 Act to the effect that if there is any discrepancy or irregularity, the certificate issuing authority can itself cancel the certificate. Push up. Insofar as the objection as to entertainability of the writ petition is concerned, the same is turned down, since the issues raised by the petitioner are of a larger canvas than a mere challenge to the illegal act of the authorities, but pertains to a jurisdictional issue as to whether the impugned order could be passed within the was passed within the jurisdiction of the respondent authorities. First up, next para, since the challenge hits at the very root of the authority, the writ petition is hereby entertained. First up, however, a question arises as to whether the rules pointed out by the private respondent and or section 9 within bracket 2 of the 1994 Act are circumscribed by section 8 capital A in the light of Kumari Madhuri Patil's judgment rendered by the Supreme Court. Push up. Hence, the writ petition shall be heard on such issue. The respondent shall file their affidavits in opposition within a fortnight from date. Reply, if any, within 1 week thereafter. The matter shall be listed on May 7, 2024 for hearing. Push up. There shall be stay of operation of the impugned order cancelling the OBC certificate of the petitioner till June 15, 2024 or until further order, whichever is earlier.
My lord, may I indicate one thing, Lord? There is a misrepresentation of fact, my lord. Kindly record that.
That will be the scope of argument.
My lord. Lord, your lordship has perhaps indicated 1996 Act. It will be 1994 Act.
1994, my lord.
You said 1996.
It has been issued on 96.
Yes, that was what I saw also. But
1994
I asked him twice. He said 96. 96 একটা জায়গাতে use করেছিল 94 হবে। ও আচ্ছা, very well. Next.
24.
96 টা বেগ না 94 হয়ে।
I beg to appear for the petition 24. My lord, on last occasion, my lord has directed that this writ petition, along with a writ petition filed by my lord senior client's client, should be taken up together.
Yes, we sent the slip, but it has been deleted from the computer section. It is ascertain করে ensure it was there.
Yesterday it was there, my lord.
I am appearing. Erroneously
It
not
was
come.
there.
No, in that file, Mr. Lahiri, also an order has to be recorded. This will be irregular. It will go back to the previous days then. Let us come back tomorrow.
My lord, in such case, my lord, may I seek something, my lord, if we day after tomorrow, subject to my lord's convenience as well as my lord, my learned.
You're also 2:1, yes. Since a connected writ petition is not appearing today in the list, let the matter stand adjourned till day after tomorrow when it will be placed under the same heading. Or ensure করে যেন থাকে।
$25.
I'm for the petition, my lord.
Mr. Singh, you are for the state
I want to state.
and you are for the distribution licensing. Yes.
Service is good, my lord.
What is the matter? No private respondent here.
My lord, I've made a private respondent a party. Since, my lord, the private respondent is my landlord, and there's a dispute with regard to the private respondent and the distribution company.
But not
No, my lord.
not
prayer
their
against-
objection.
No prayer against them. They have not objected, my lord. Kindly, my lord.
They are the main party because one connection is to be
Served.
Serve. Service is
What
good.
is the matter?
My lord. My lord, I have taken a property on rent, my lord, for my lord commercial purposes. My lord, my After that, my lord, I've obtained trade license. Thereafter, my lord,
Both are annexed. Both are annexed.
both are annexed.
Yes, then.
Thereafter, my lord, apply for new connection. My lord, the amount was paid. After that, my lord, kindly takes up, my lord, page 20, P5. P5 is their letter, my lord, where, my lord, they say that a title suit is pending with regard to the said premise with regard to, my lord, against the private respondent, my landlord. So, my lord, the formalities are incomplete. My lord, I say, my lord, that I apply for independent connection. My connection, my lord, should not be dependent on the fate of that title suit. That is, my lord.
No, you are asking for an independent connection in a multi-storied building. Probably
My lord.
it has to be given through the common service connection, main service connection. Is it
My
an
lord.
incomplete building?
No, my lord. Complete building, my lord.
Then take the connection from there. You cannot get a separate service connection. You can get a metered connection from that main service connection.
My lord, kindly, my lord, takes up, my lord, page P3 and P4. My lord, page P3, my lord, I apply for a connection. They tell me deposit this much amount. That is also done.
No, after that, the inspection takes place. After you deposit, the inspection takes place. Where is that? You applied for a service connection?
Applied, my lord, takes up, my lord, P4, my lord, page 14 once.
No, P3 we have to.
P3.
New connection you have said.
New connection.
So it may be a metered connection also.
My lord.
Yes. Only difficulty is this, my lord, he has rightly said that respondent number 6. He is the owner of the entire premises. It's a multi-story commercial complex. Lot of flats are there. He is one of the tenant therein. And there is one showroom. There is one lodge and all these will be running. And that's why the main owner, he made an application for connection. Now initially made an inspection. He applied for 61 kVA connection. After inspection, we found it is required 91 kVA. And accordingly, quotation was raised, which was 9 lakhs and odd. And he undertook to make the payment, but he has not paid.
So there is no main service connection.
No connection.
What are the others doing?
Nobody is getting.
No, it's that P5, my lord, it is immediately in the last paragraph, my lord, see, the form has not been properly filled up.
So that is one
By that person.
That is one of the important things.
So what can he do? Then he is entitled
Only,
to.
one thing, he is in agreement with the landlord. Because connection will be there. Landlord is the main owner. He will take connection and everyone will enjoy it. And
But then he'll have to wait indefinitely for the landlord.
That's the tenancy he has taken thereafter, after making application, after entering into the agreement, lordship. But that's the liability of the lord, certainly the landowner.
Which is the relevant portion according to you of the tenancy agreement?
That is not with me right now.
No, it's annexed. Annexed.
All copies.
You are saying as per
I'm very sorry to say that in our petition, nothing has been supplied to us. I am not taking the plea right now. No, nothing has been given to us.
This is your letter.
No, that is from you. I find it from you. I find it.
That is
Not in our copy. What has been served? Original copy, my lord, I have received.
Their letter.
No,
Yes.
I have received. Nothing has been given to us.
My lord, you come to my
Not
lord.
from NET, from the office copy.
P5.
The item number 3, Roman 3, lack of requisite documents, that is ownership, occupies documents.
No, ownership it does not require, Mr. Singh. Occupation is sufficient.
Then, my lord, the next one, my lord. Format is lying incomplete was a prescribed application from WPCHJ.
These he
for
can
new
produce.
service connection.
No, the important is the first one. Child connection in a multi-storied.
Lord, that's the important. That's the important, and quotation has been raised 9 lakhs and odd. Let him make the payment, he will get
No,
connection.
Mr. Nayak, you have this Form A or some schedule.
Procedure A and procedure B, Lord.
Procedure B is for independent connections to multi-storied
No.
buildings?
No.
What is that for?
Procedure A for independent connection, but in case of multi-story, only procedure B will be for. Where one service connection will be taken, that collectively that should be taken. Thereafter, everyone will get it. How they will get it, because they are entering into a multi-story building, so they will have to find out the way. Has it been independent?
Then you have to assert your rights against your owner, the landowner.
Well, the difficulty, my lord, is I'll just.
Because independent connections cannot be given in multi-storied buildings. Technically, it is not possible.
Well, the difficulty I'll indicate, my lord. My lord, there was a my lord quotation, my lord, as my lord rightly pointed out, my lord, my senior friend, my lord. Quotation was raised.
He is not complying.
That was, my lord, not complied. They, my lord, tried to disconnect. That was stayed, my lord, by the learned trial court. My lord, there is still connection. But, my lord, my connection is not there. My lord, there is connection with respect to the building.
That was construction connection. That is not for commercial purpose. That is for constructing the building, a different connection is
They
given.
were using it, somehow it was managed, Lordship. That's it.
Now I'll give you liberty to approach the appropriate authority, including the civil code for ventilation. You can approach the civil code and ask for this direction on the landlord or a permission to get. And even then he has to do something. Otherwise you cannot get electricity.
My lord, the difficulty is the quotation. My lord, the quotation that they have raised, that dispute, my lord, is still pending before the, my lord, the learned civil court. My lord, until, my lord, that gets resolved, my lord.
You cannot get connection because of the technicalities. Unless that is resolved, you cannot get connection.
Had it been independent premises, there was no problem.
Yes.
And he knows that it is a multi-story building and these problems are there.
The petitioner submits that the petitioner is a tenant in respect of a multi-storied building and intends to run a business there, for which purpose a commercial electricity connection was applied for. Upon the petitioner depositing, complying with initial formalities, the WBACDCL wrote to the petitioner expressing its inability to give such connection on several grounds. Apart from other grounds, court case and legal obligation, lack of requisite documents, formalities lying incomplete, and that the petitioner is seeking child connection in a multi-storied building, which can only be processed after effecting the main service connection, were cited by the WBACDCL. It is argued that as an occupier, the petitioner is entitled to an independent connection at the premises to operate his business. That apart, the petitioner is armed with a tenancy agreement which entitles the petitioner to legally possess the premises. Next para, learned counsel for the WBACDCL submits that even if the other formalities could be taken care of, the first ground of objection still remains. It is that in a multi-storied building, independent individual connections, better known as child connections, can only be processed after effecting the main service connection under procedure B, P capital. Procedure B as per the norms of the WBACDCL. In the present case, since the owner stroke landlord has not complied with due formalities for getting the main connection, the main service connection could not be given, and as such, consequentially the child connection sought by the petitioner cannot also be given. Learned counsel for the petitioner submits that there is existing electricity connection at the premises which is being enjoyed by the landlord. Next para. However, it is clarified by learned counsel for the WBACDCL that the said connection was for the limited purpose of making the construction, which falls under a different category than a commercial connection or a bulk connection as sought in the present case. Next para. Upon a comprehensive consideration of the arguments, it transpires that the WBACDCL is technically impeded, impeded from giving individual independent child connection to the petitioner, in view of the nature of the building, which is a multi-storied building, where independent connections being given would cause a huge load factor, which would be detrimental to the safety and security concerns. In any event, the WBACDCL norms do not permit such connections to be given except from a main service connection. Since the private respondent landlord chooses not to appear despite service, the stand of the private respondent is not clear. What is evident is that due to the non-compliance of formalities by the private respondent, the main service connection cannot be given, leading in turn to the petitioner being deprived of electricity. Hence, the only option before the petitioner is to ventilate his grievance. There is already a pending suit.
Already a pending suit.
In the pending suit between the petitioner, where the petitioner and the private respondent, seeking appropriate reliefs to ensure that all formalities regarding main service connection are complied with to enable the petitioner to get a child connection. Upon such order being passed by the civil court, the the petitioner will be at liberty to approach the WBA-CDCL afresh, intimating the same, upon which the WBA-CDCL, comma, if otherwise compliant legal formalities are complied with, comma, shall give the connection to the petitioner in due course of law under procedure B of the WBA-CDCL norms. No rest to cause urgent certificate.
My lord, I'm praying for leave to mention a matter. The contempt application being filed against the district magistrate, principal secretary was being called and all. The money which has been order being passed by this honorable court already been paid. But neither petition is taking any, initiative to bring this matter before this. I received this brief almost.
No,
more than-
contempt is not pending, not appearing in my list.
No.
Mr. Singh, unless the petitioner applies.
But the problem is when the petitioner has received entire money. I
Yes.
don't notice. Tomorrow if something.
If the petitioner does not want to press the matter, or the court cannot show him to take it up, or the respondent cannot, the alleged contemptor
But for
cannot.
my safety, my lord.
No.
I'm praying for my safety. All district magistrate, the principal secretary.
Yeah. Unless I pass issue a rule of contempt, what is your safety hazard?
What I can do, my lord, please put it in the list. I will give
No,
you
no,
the
no.
notice. I'll serve a notice.
No, not at the instance of the alleged contempt, not at the instance of the respondent.
This is the main difficulty, my lord.
There is no order as yet. Yes.
Time for the petition.
I'm appearing on behalf of CS. Lordship, petitioner is a tenant in respect of a short-form trade license is their lordship applied for commercial connection. No steps have been taken, lordship, for this said connection.
My lord, this is a large, very old.
Use the mic.
My lord, this is a very large, old amalgamated commercial building in a congested market area, my lord.
Block meter.
Block meter, my lord.
Lordship, may I take instruction, lordship?
Learned counsel for the petitioner submits that the petitioner applied for a commercial electricity connection which is not being given by the CSC Limited. Push up. Learned counsel for the CSC Limited contends that the building where the connection has been sought is a large, old, amalgamated, what other definition? Commercial building where even another connection being given may cause a safety hazard. Push up. The option before the petitioner is to apply for a block meter connection along with other inmates of the building. Full stop. Learned counsel for the petitioner seeks 2 days adjournment. I'll keep it on Monday. 2 days adjournment for taking instructions on such issue. Accordingly, let the matter be placed in the list on April 8, 2024 for passing further orders under the same heading.
My lord, this is for new connection, my lord. After receiving the letter of upgradation, they have provided the electricity.
I'm for the CSC.
Right.
Already 26.
Learned counsel for the petitioner in his usual fairness submits that after filing the writ petition, comma, the electricity connection sought in the writ petition has been given to the petitioner. Accordingly, WPA 811 of 2024 is disposed of as infructuous in view of the above development. No address to cause urgent certificate. Thank you.
28.
Yes.
This is my affidavit of service.
Right.
Lord, I participated in an auction sale.
Yes.
Lord, by the bank. I was declared H1. Lord, sale intimation was given to me. The sale certificate has not been issued. In terms of Rule 96 of the Securitization Rules 2002. Despite I having tendered the entire money in terms of the e-auction notice.
That is the grievance.
That is so sole grievance.
Well, I have two-fold of submissions. First is that very innocuous, my lord, that my lord may allow this prayer A and B. I am also choosing the same thing. My lord. And second is that why I did not do so till now. There is a restraining order, my lord, from DRT, that is why I did not do so. But it is an unusual order, my lord, this is without rhymes and reasons. So my lord can pass an order to allow this prayer A and B.
Please give a copy to
Yes,
Mr.
yes, please.
What was the occasion to pass this? I mean, he's a party there, no?
No, there's
Obvious.
no part.
You are a party there.
I am obviously against bank only.
At whose instance was this? taken?
Borrower only.
Borrower. But then without implementing the borrower, should I pass that order? This is a competent
Very
forum.
innocuous order, nothing doing without any rhymes and reasons. Can you see, my lord? I am also, they have paid more than 12 crore rupees, 12 crore and 4
Both
lakhs.
of you agree, but this borrower is enjoying an order from a competent forum.
This is not extended thereafter.
I'll record that and pass.
I'm grateful. I'm grateful. But do not record that I am consenting to that.
No. But I'll record that this has after this date this has not been extended. That I'll record. Learned counsel for the petitioner contends that the petitioner being a successful auction purchaser, complied with all formalities, but the respondent bank has not yet issued the sale certificate with regard to the auction purchase in favor of the petitioner, prompting the petitioner to move the present writ petition. Push-up. Learned counsel for the bank in principle has no objection to issuance of a sales certificate, but submits that the bank's hands are restrained by an order dated January 3, 2024, passed in case number SA 387 of 2023 with regard to certain interlocutory applications passed therein, which was instituted at the behest of the borrower. Pushed up. Next para. However, learned counsel for the bank also submits that the said order was passed for a limited period and has not since been extended. Push up. Next para. A copy of the order is handed over in court today, from which it appears that the concerned debts recovery tribunal had directed the respondent bank to maintain status quo in respect of the property till the next date of hearing. Full stop. Preceding the said restraint order, the expression within double inverted in the meantime, double inverted close, was used, thereby and whereby it can reasonably be concluded that the order was subsisting till the next date of hearing as fixed in the said order, which was January 8, 2024. Full stop. First, since the order has not been extended, there cannot be any further fetter by the for the bank to issue the sale certificate in favor of the petitioner. Full stop. Secondly, the petitioner, not being a party to the said proceeding, cannot be unnecessarily bound by the rigors of such order. Full stop. In the present case, all norms of equity lean in favor of the petitioner, since the petitioner is suffering due to no fault of its own, having complied with the formalities in pursuance of the auction purchase held at the behest of the bank. Full stop. In such view of, moreover, strictly speaking, the sale in question has already been transacted for all practical purposes. Push up. The mere formality of issuance of a sale certificate, which would give a conclusive color to the same, is merely left to be done. Push up. Thus, it cannot be said that the status quo passed in favor of the borrower in a proceeding where the petitioner stroke auction purchaser is not a party can restrain the bank from issuing the sales certificate for an already concluded proceeding otherwise in favor of the petitioner. Accordingly, WPA 8223 of 2024 is allowed on contest, thereby directing the respondent bank to issue a sales certificate pursuant to the auction purchase auction sale held in favor of the petitioner at the earliest, preferably within 3 weeks from date.
Your physical possession is my prayer B, which my learned friend did not object, has in fact said that A and B both should be allowed.
Are you in occupation?
No, they will hand over the.
Are you in occupation?
Yes, yes.
Not in third party occupation.
No. My physical possession.
The respondent bank shall also hand over the physical possession of the property within the said period of 3 weeks in favor of the petition.
May I have only one small request, my lord? May we adjust the amount, whatever they have paid to add in the loan account, whatever there is. Whatever they have paid has to be adjusted. We have not adjusted.
It is made clear that nothing in this order shall prevent the respondent bank from resorting to due process of law for adjustment of the balance account of the loan from the sale proceeds.
But after the possession is handed over, otherwise,
No.
I'm grateful to my
Thank
lord. I deeply obliged.
29.
My lord, 29, I appeal for the petitioner, my lord.
Yes.
But the petitioner before your lordship is a candidate belonging to economically weaker section, my lord. Time to time, my lord, certificates were issued by the competent authority.
May I pray for some time in this matter for instruction, lordship?
This is what is the matter about? I mean,
issuance of economically weaker section certificate. He has not been given that.
let him take instruction.
A certain
Sometimes when he takes instructions, you get a relief.
My lord, certainly, my lord, but kindly give a short time because I have been
the short time.
I have been given a provision appointment letter. Until and unless I produce that, Lordship, kindly
Mr. Kalib, take instructions quickly. Come back on Monday. Come back.
Lordship.
In affidavit of service filed to be kept on record. An adjournment to take instructions is sought on behalf of the state. Full stop. Accordingly, let the matter be listed on April 8, 2024 under the same heading, fairly at the top of the list.
Grateful.
Arithro, এটা আপগ্রেডের উপর দিকে।
30.
May I please, your lordship?
Yes.
Lordship, affidavit of service is ready. Everybody has received.
Regarding mentioning, have you given notice? Check
Yes,
that. Sometimes those points are
Mentioning?
mentioning for upgradation.
Yes.
You have not given any notice for that.
Notice there, mentioning and notice.
Come back tomorrow. Because several matters objection is being taken that no notice of mentioning for upgradation is given.
Oh,
I'll keep that on record. I'll ask you to give a notice.
Yes.
I'll keep it on Monday under the same heading.
Your lordship, the only urgency, if your lordship kindly keep it any day this week because his savings account has been kept on hold. He's a senior citizen matter.
Understand, but
not able
today
to-
we are tomorrow. Can you do it by today? The notice. Very well. I'll keep it tomorrow. Affidavit of service filed today be kept on record. Full stop. None appears for the respondent. Full stop. Since no notice of upgradation has apparently been given, comma, the learned advocate on record for the petitioner shall serve a notice indicating that the matter shall be taken up under the same heading tomorrow and file a receipt when the matter is next called on for
I
hearing.
will gratefully.
Serve a notice on the respondent, comma, directly or through his learned advocate.
Thirty-one.
Madam, for the petition led by Mr. Sanal, my lord, he's trying to be online, my lord.
Yes.
He's on virtual mode, my lord. He's trying to, my lord.
He's trying to.
My lord.
Try করছেন? হ্যাঁ? Join. ওদিকে problem আছে তাহলে net connect.
My lord, I'm appearing for the private respondent number 6.
Yes, but
seeking.
What is the matter about?
My lord, it's a tender, my lord, process, my lord.
My lord,
I'm filing my affidavit of service, my lord.
I'm seeking
Lord,
pass
it's a-
over, my lord. Senior is based in some other courts.
I'll take it up tomorrow. Ask Mr. Shanal to be present tomorrow.
My lord, your lordship, kindly, my lord, some, my lord, on the top.
He's already happy. No top. Tender
My
matter?
lord, if the, my lord, if the other matter will, my lord, come, my lord.
What other matter will?
My lord,
Other matter will come at the top.
Then, my lord, any
No,
time.
I was inquiring from my officer that system now is apparently that it does not depend on me totally. I mean, if I say at the top, then it appears at the top. Otherwise,
I know, my lord. That
what
I
happens?
know, my
No,
lord.
not that. Not that. Suppose today I take up to 12. There are 50 matters, upgraded matters. So tomorrow, under normal circumstances, from 13 to 50 will be taken up first. Then the next matters which are to be added. But what the section does now, digital filing, according to the serial number. So I don't have control over that. I cannot put this at top because top is only extremely urgent matter.
My lord, only difficulty, my lord. Otherwise, no. My lord, if, my lord, they can, my lord, issue the work order anytime, my lord.
Then you can start hearing now, right? Yes.
My lord,
You are led by whom?
Sir, for private respondent number 6, my lord.
That, but there is extreme urgency. I have to take up the matter.
So senior is with some other court, my lord.
No, nothing doing. Yes.
My lord, the
But probably I cannot finish it today. In 15.
then your lordship, my lord,
I'll এটা তাহলে উপরে
some
একটা
preference, my
একটা
lord.
টপ দিলাম না তারপরে দিয়ে দিই This will appear fairly at the top
My
tomorrow.
lord, I'm grateful.
Affidavit of service filed today be kept on record and adjournment is sought by the respondent number 6 who sub due to some technical snag comma the learned counsel for the petitioner cannot appear online. Let the matter be adjourned for the day and be listed tomorrow under the same heading fairly at the top.
Grateful.
Grateful, my lord.
There are 2 or 3 other matters after that.
Grateful, my lord. Deeply obliged.
হ্যাঁ ও তাহলে তো এটা উপর দিকে থাকবে ঠিক আছে দেখো নেক্সট ম্যাটার
Next matter, my lord.
32
Yes, I pay for the my lord.
respondent number
2 to 6.
respondent number 6 has escaped. Yes, previous matter. Sorry. Yes,
My
please.
lord, I'm appearing for the petition in this matter. I'm led by Mr. Das in this matter. He's on his way to the court.
Which Mr. Das?
My lord, can I request for a short passover?
Which Mr. Das?
His name, his full name.
Don't know the name of his name.
Yes, Sujonil Das.
No,
Mr.
you,
Sujonil.
you are Miss Indoria.
Yes.
Start the matter. Otherwise, it goes down under the regular heading.
My lord, just a small passover.
He is not Mr. Das. Changed your surname.
No, no. May it please your lordship.
Yes.
I beg to appear on behalf of the petitioner. I challenge, my lord, the action undertaken, my lord, by the Union of India, my lord, and the ESI hospital, my lord, in awarding, in their attempt to award a tender, my lord, to a person who is admittedly on the face of it ineligible, my lord. Now, my lord, before that, my lord, where is the supplementary affidavit? Yes. But there are certain subsequent developments, my lord. My lord, pursuant to, my lord, the model code of conduct, my lord, coming into operation, I am the existing contractor, my lord. My term has been extended for a further period of 2 months now. But, my lord, that doesn't alter the position, because I'll tell you, lordship, my lord, what has happened. Now, this is, my lord, for washing of hospital linen and laundry services, my lord.
Public. In public.
Hospital, my lord.
Hospital.
Yes, hospital.
Yes, in
Washing dirty linen in public.
This is my lord, for cleaning linen, my lord, in public, my lord. Or rather for the public.
You said washing, that's why.
That's how they have described it, my lord.
Your bid has been rejected.
No, it has not been rejected, my lord. I am saying, my lord, a person admittedly ineligible, my lord, who is not having, my lord, the experience which is required, my lord, which is an essential criteria, as well as the annual turnover, my lord, as required, my lord, for the period as has been sought for, my lord. Now, he has been also, my lord,
he has been allowed at the technical stage.
My lord, he has been allotted, my lord, the technical stage, my lord. He is now, my lord, earmarked as the L1, my lord.
Work order has been issued.
After financial bid, work order.
Yes, work order has been issued, my lord. My lord, my learned friend grievance is only, my lord, 1. My lord, he does not have turnover. Number 1. Number 2, my lord, he is still, my lord, he's continuing, but his turn is over.
No, obviously, that's why he's.
Number 1. My lord, that has been, my lord.
There are 3 number ones already.
My lord, government of India has already relaxed that, my lord, turnover condition, my lord. If your lordship kindly takes that, this, my lord.
But I was about
Mr. Bhattacharya is looking down upon you. Literally.
I expected my learned friend to look up, my lord, so that I am able to, my lord.
He looks up to you, yes.
So that I am able to, my lord, place my case.
Yes,
yes.
If I am permitted to. Now, my lord, this is for, my lord, washing of hospital linen and laundry.
Don't start from the beginning, Mr. Bhattacharya.
It's a 500-bedded hospital, my lord.
What is the criterion? Tell me the criterion and how he does not qualify.
My lord,
Who
kindly
is
comes
appearing
to,
for
my
the
lord.
you are for the private respondent.
I am for the private.
You are for the private.
My lord, kindly comes to, my lord, page 18 of the writ petition.
Yes.
Page 18, my lord, will find, my lord, kindly marks. At the bottom, my lord, financial statement, that is audited balance sheet and profit and loss account for 1920, 2021 and 21-22. And then proof of experience of mechanized laundry service in an organization thereafter. Thereafter, my lord, kindly takes page 21 once, my lord. 21 further clarifies the position. These are the general conditions of contract. This is my lord again serial number 3 and 4. Experience certificates for 3 years in the last 7 years. This is one. And the other one is the tenderer should be a profit-making concern with a total annual turnover of not less than 50 lakhs during the financial years 2019-20, 2021 and 21-22.
Right.
Now there is, my lord, special terms, my lord. There are reasons, my lord, why I will be relying on the special terms, pages 28 and 29, my lord. But against, my lord, serial number 3 in the special terms, my lord.
Yes.
It reads, my lord, that such linen after being washed, dried and ironed shall have to be delivered back to the respective units from where they have been collected at such intervals that may be prescribed to him. And in the case of linen belonging to the operation theatre at such intervals as may be operation theatre, labor room, minor operation theatre, casualty, the same shall have to be delivered back as fast as possible, but not later than 1 day. Thereafter, my lord, the tenderer agency shall use highest grade of washing materials, reagent, disinfectants, coloring agents, whitening agents, etc. for maintaining proper washing, durability of the linen and attaining adequate disinfection. My lord, may kindly mark disinfection, my lord. The next page, my lord, if my lord kindly turns overleaf, my lord, it's against, my lord, clause number 10. The successful tenderer should make arrangement for a dedicated workshop for the use of ESIC hospital to ensure cleaning, drying and delivery of linen within the time schedule and for prevention of cross-contamination. So, my lord, this is a matter, my lord, which concerns, my lord, health and safety, my lord, of, my lord, the patients who are admitted, my lord, in this particular hospital, my lord. Now, what has happened is, my lord, this, my lord, the private respondent, now they are admittedly incorporated, my lord, on the 30th of January 2020, my lord. I have annexed documents to that effect, my lord. Page 40, my lord, will find, my lord. These are all, my lord, public documents, my lord. Page 40, the private respondent's date of incorporation is 30th of January 2020. My lord, the question is, my lord, about turnover, my lord. The turnover cannot be, my lord, 50 lakhs and above, my lord, for the period 1920, 2021, 2022, my lord. Now, my lord, I address a representation, my lord, which is at page 38, indicating that these facts, my lord, that there must have been misrepresentation when the private respondent has uploaded the documents online. Now, that representation was kept pending, my lord, and in the meantime, my lord, they were attempting to, my lord, finalize the tender. Now, my lord, on 20, we filed the writ petition, my lord, and the same was received, my lord, by the ESI hospital on the 23rd. Now, on the 26th of, my lord, this month only, my lord, or 26th of March, now they reply back to our representation. My lord, the supplementary affidavit, my lord, is in the way of getting affirmed, my lord. If my lord permits me, my lord, may I place, my lord, my copy? Can you give the copy of
No, need not. For the timing, just place the facts.
Now, they have taken a point, my lord, that no, in terms of a 2014 MS circular, a policy, MSEs, in respect of MSEs, that is medium and small enterprises,
Micro.
Micro and financial.
MSME.
Yes.
Micro, small and medium enterprise.
That in respect of these particular MSMEs, there can be relaxation which can be granted. This is one. And the second point is that no MSMEs bid has been rejected on the ground of not meeting these two criteria. On these grounds alone, they have specified on the word alone. Why? Because, my lord, one of the bidders, my lord, who is absolutely similarly situated, my lord, similarly placed, his bid has been rejected, despite he being an MSME. One of the grounds of rejection, my lord, which has been cited, are, my lord, not meeting, my lord, the experience. So now, the question, my lord, which requires interpretation of the honorable court is, my lord, it's a very short point, my lord. Whether a tender document where the conditions do not specify about a relaxation, whether that relaxation can be introduced subsequently for singling out the successful bidder, my lord, or rather for awarding him the contract, my lord, whether it can be tailored in such a fashion so that a person who is the blue-white participant, my lord, can be awarded the tender, my lord. Now, this is the short point, my lord, which is there.
Do you have a copy of that relaxation?
Yes, I have.
I do, my lord. I do, my lord. There is again, my lord. Can you please give me a copy at least? You should have been ready. I mean, for the past 2 days, I have been. This is supplementary. Well, may I have your lordship's kind?
have a-
Well,
yeah.
no, the supplementary affidavit has been affirmed. my lord.
Copy has been served upon.
I'll do that right away. my lord.
এখন দিলে কি করা?
I'll do that right away. It is not for the successful for the private response. আমার copy? Affirmed হয়নি? তাহলে দিয়ে দিলেন কেন? মানে it is কি করছেন আপনারা? Don't do this. Yeah. What is wrong with you people? It's not yet affirmed. What is happening?
বুঝলে? এটা তো ডাটি লিনেন হয়ে গেল।
Huh?
ডাটি লিনেন
Ah,
হয়ে গেল।
dirty linen basically.
এত পরিষ্কার পরিচ্ছন্ন কথা বলছি কেন?
My lord is at the letter dated 26th of March 2024.
10th March.
2016.
16.
Yes. Yes, my lord, there are, my lord, further clarifications, my lord, after this 10th March, my lord, 2016 notification. They are not relying on it, my lord. I have the entire bunch, my lord.
We'll continue tomorrow because today after 2 p.m. I have a special bench with Justice Shane and
In the
Justice
meantime, my lord, I'll also get the supplementary affidavit.
Do that, do that, do
Yes.
that.
I tender my apology, my lord, because the supplementary
it's
was
all
not affirmed.
Leave is granted to the petitioner to file a supplementary
Grateful to your lordship.
affidavit when the matter is called on for hearing tomorrow with advance copies to the respondents during the course of the day. Full stop. The crux of the present writ petition is the challenge to the private respondent being accepted as a successful bidder despite the private respondent not fulfilling the prior experience criteria as stipulated in the tender in question. Full of Learned Counsel for the petitioner argues that in view of no relaxation under the corresponding circulars of the government having been mentioned in the tender, comma, whether the respondent authorities were justified in granting such relaxation after floating the tender and after participation of the bidders. Full stop. Next para, be that as it may, comma, due to paucity of time, the hearing cannot be concluded today. Let the matter be listed tomorrow under the same heading. A copy of the office memorandum dated March 10, 2016, handed over by Learned Counsel for the private respondent today be kept on.
Good. But meet by 2 o'clock tomorrow, my lord.
2 o'clock, all 2 o'clock still probably 18th of April.
Then, if my lord is pleased enough, my lord, to fix any time, my lord.
No, let it remain in the list as it is. There are too many 2 o'clock matters every day. So in any event, I won't be able to reach this also.
Grateful to you, lordship.